The Lord is my shepherd, I shall not want. He makes me lie down in green pastures. He leads me beside quiet waters. He restores my soul. He guides me in the paths of righteousness for the sake of His name. Even though I walk through the valley of the shadow of death, I will fear no evil, for You are with me. Your rod and Your staff, they comfort me. You prepare a table before me in the presence of my enemies. You anoint my head with oil, my cup overflows. Surely goodness and mercy will follow me all the days of my life, and I will dwell in the house of the Lord forever. The Lord is my shepherd, I don't want for more. He lays me in green fields by the still shore. He brings my soul home when my path runs dry. He leads me, even if I lose my way. He knows my name. Even if the dark gets close, He stays the same. The Lord is my shepherd, I will not fear. He walks right beside me, He keeps me here. The Lord is my shepherd, my cup runs over, mercy in every step, grace on my shoulders. He leads me straight on the right road, line for His own good name. He makes it shine when I walk through the valley of death's deep shade. I won't break down, I won't be afraid. You're with me, Your rod, Your staff, they steady my heart. When the night feels long, You light the dark. The Lord is my shepherd, I will not fear. He walks right beside me, He keeps me here. The Lord is my shepherd, my cup runs over, mercy in every step, grace on my shoulders. You set a table right in front of my foes. You anoint my head and You overflow. Goodness and mercy will follow me home all the days I breathe. I'm never alone, never beside me, He keeps me here. The Lord is my shepherd, my cup runs over, mercy in every step, grace on my shoulders.
Grace and peace, everybody. You saw the thumbnail. You saw the title. You know what we're about to do. We're about to finish up. It's day 5. We've actually made it, y'all. I can't believe it. It's day 5. Shout out to the best live chat on the internet. Thank you, everybody who's already tapped in, hit the like button, jumped in, say what's up to your people in the best live chat, the most electrifying comment section on the planet. All right. Trial starts in about 30 minutes. Dr. G did an analysis of Tyler Robinson. You saw that video earlier. I dropped that video earlier today. But he also did an analysis of Lance Twigs. And I thought it was super informative, as well as Judge Graff. So I thought this was good. I want to bring this in. But thank you, everybody who's already hopped in. Thank you so much for popping in and saying hello to your people. All that kind of good stuff. I appreciate y'all. Let's get this thing going. I do want to pray, and then we're going to make it happen. Father, I thank you today that this is the last day of this preliminary trial. I do thank you that it's gone this far without any problems, and I pray that today will be the same. I do ask that, Lord God, you will touch the hearts of those who are there, the lawyers, the judges, of course, the Tyler Robinson who's being tried, as well as those persons who are in court, as those who are watching, that, Father God, they will know that ultimately you are our judge, and that you will, Lord God, judge fairly and swiftly, correctly and justly, Lord God. So no matter how this pans out, no matter how this is, how this works out here on earth, we know that you ultimately will judge fairly, Lord God, and we do thank you for that. I do also pray, as I've been praying all week, Lord God, that you will stop Candace Owens' mouth, that you'll remove her platform, that you will stop the lies and the false narratives that she's been telling, that, Lord God, peace can be brought back into this situation, Lord God, and not the foolishness and the shenanigans that she's been introducing. So we thank you for all that in Jesus' name. Amen. Let's get going with Dr. G. Dr. G, get on up here to the front of the church, sir. How's it going, sir? Let's go. Let's go. Green hearts in the chat, my people, when you can hear.
Hey everybody, Dr. G here. I'm a clinical and forensic psychologist as well as a body language expert, and today we're going to be analyzing more evidence from the Charlie Kirk assassination hearings. Before we get started with this, a couple of quick things. One, I wanted to make sure you know this is not a psychological evaluation of any kind. These are just my opinions. In addition to that, I do want to remind you to like and subscribe if you want to see more content just like this. All right, let's go. What we're going to be analyzing today is more information provided during the Charlie Kirk assassination hearings. We're going to be looking at more of the evidence provided by the state in their case against Tyler Robinson. What we're going to be analyzing first is an interview with Tyler Robinson's former roommate, Lance Twigs. Then we're going to be looking at text messages sent by Tyler Robinson. And finally, we're actually going to be watching the judge's reaction to Charlie Kirk's assassination. We're going to be looking at some of that body language, more forensically oriented on the first half, a little bit of body language at the end. All right, let's just jump right in.
So he acted erratically. Was he pacing? Was he just sitting down, relaxing?
No, he was walking around a lot.
Right, and that's within the home.
Mm-hmm.
And did he talk about what he had done?
Didn't go into detail. I just asked him in person if what he said was true the night before, and he said it was. I started crying a little bit and said he wishes he hadn't done it. And then kept going around him.
Now, there is a lot of value in what is being said right now. One is that so many people, so many outlets, there were a lot of conspiracies going around about whether or not the text messages that were sent were authentically between them. This confirms that they very much were. These were actual text messages that were between Lance Twigs and Tyler Robinson. In addition to that, not only were those text messages authentic, but the following day, when he was with Tyler Robinson, from what Lance Twigs says, in fact, confirmed that what he had said the night before was in fact true, that he had in fact done this.
Just doing stuff, I think, to keep himself busy or distracted or something.
Okay. Did he talk about what he was going to do next?
They're only showing brief clips of this, but I do want to point out that in terms of how valuable this is forensically, things like this are a slam dunk for the prosecution. When something like this is shown to a jury, it is very, very hard for a jury to talk away why he would make something like this up. This is someone who is credible, someone that knew Tyler Robinson well. So something like this for the defense is not good. I would talk some about the body language of Tyler Robinson during all this, but they don't show him. They actually didn't show him at all today from what I could tell.
And then eventually said that he would talk to his parents or turn himself over.
Okay. And when you left, was that how you left, understanding that he was going to turn himself in or go to his parents' house?
Yeah, and I didn't really want to be at our apartment while any of that was happening, regardless of what went down.
And just to be clear, in terms of body language, I'm not doing a deep body language analysis of Lance Twigs, but you're seeing somebody who is not needing to pacify themselves. I'm sure it's very uncomfortable to talk about these things, but if there was a lie, if there was a big lie that someone was being forced to say, you're going to see them stroking their face, getting very anxious when they're talking about this. You might get anxious just talking about the content of it because of what it was, but he seems to remain fairly calm. You would, on the other hand, be anxious if you were making this story up, if you were making up a lie. We're not seeing anything that Lance Twigs is doing as far as pacifying behaviors go. So I have no reason to question any of this testimony at this point.
And had you seen the images that were released of the suspect?
I did the next day. I don't think I saw any on the 10th.
I'm going to show you a couple of those images. Here on the screen, you see these, looks like there's 2 rows of 3 images.
Mm-hmm.
Do you recognize the person in these images?
I wouldn't say it with 100% certainty just because of camera quality, but that looks like him in terms of the shoes he's wearing, the sunglasses. I don't think I'd specifically seen him wearing that hat, but he was usually wearing a hat, and then jeans. So it definitely, especially the bottom, the last 2, definitely do look like him.
And that's extremely important because the middle picture right here is one that conspiracy theorists, and well, actually the one on the right as well, that a lot of the conspiracies that circled around saying this is definitely not him, this doesn't look anything like him. This is someone who would know Tyler Robinson very, very well. So the fact that he is able to identify him with as much certainty as anybody could be identified with this camera quality does speak volumes, and that it also is information that will be very, very compelling to a jury. So if this goes to trial, this evidence, particularly Lance Twiggs' take on this evidence, will be very compelling.
The Dremel that you talked about, you said he had asked for that, is that right?
Mm-hmm.
And had he told you it was to inscribe bullets?
Yeah.
And
the level of detail that is being provided by Lance Twiggs here is going to be extremely compelling to a jury when he is able to say, yes, I have a relationship with this person. I know this person. He specifically asked for a Dremel tool to carve into bullets, to inscribe bullets. And Lance Twiggs is proving to be a reliable historian based on the way the information is being provided, the level of detail. You're going to hear the level of detail about the Dremel tool and where they kept it and so forth. This is the type of information that juries like to hear.
have a Dremel then?
So I was wondering, what if Lance Twiggs decides, you know what, I do want to testify, throw all caution to the wind. I will go and testify. And he says the same thing, but he actually comes. Can he come still, even though he's done basically a video deposition? I wonder that. And I'm sorry, I do not think that carving messages into bullets makes sense. I'm sorry. That makes no sense at all to me. That is not something that even remotely sounds normal. I apologize. I don't know what I'm missing. I don't know where they do that at, but using a Dremel tool or file or whatever to put messages into bullets makes no sense at all. I'm sorry. That part right there is not passing the smell test. That makes no sense at all. None whatsoever. Let's go.
Yeah.
Okay.
It was in our our apartment. We had a section where we kept all our random tools for household stuff in our lower basement level pantry. So yeah,
that's very different than when someone goes, I don't remember. We probably had a Dremel. I'm not sure. He probably asked for it.
Crazy work.
Because that's the kind of information you can get sometimes in jury trials in situations like this. But Lance Twiggs is able to provide very detailed information about it, and that really plays well for the state. So now we're going to be looking at some of the text messages that were sent. And the reason this is so significant is what was provided publicly at that time. What everybody was talking about, what so many people were saying was that this is all fake, that nobody actually talks like this. People don't really communicate this way. They have to be fake, so on and so forth. These very much are being entered into evidence. These are very much real. We're going to hear him reading through some of it, and we'll continue to talk about it.
From Tyler. It says, drop what you're doing, look under your keyboard.
And I apologize. Let me stop you there. How do you know that that message would have been from Tyler Robinson?
That's just, so any of the messages in gray would be from Tyler, and messages in blue would be from Lance. It's just the way the iPhone distinguishes the messages. And also Lance in his interview also acknowledges that, who was saying what.
And up at the top,
So Lance confirmed during the interview that these text messages were very much sent between the two of them. These are very much real.
who do we see that this thread is between?
Tyler. So after that, then Lance responds, he says, what? And then he says, you're joking, right? And then Tyler says, I tried to delete that.
If we could scroll down to page 2.
And then Tyler says, I'm still okay, my love, but I'm stuck in Orem for a little while longer yet. Shouldn't be long until I can come home, but gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you. And then Lance replies, you weren't the one who did it, right? And Tyler says, I am, I'm sorry. Lance says, I thought they caught the person. And then Tyler says, no, they grabbed some crazy old dude and interrogated someone in similar clothing.
So these are the exact text messages that were provided a long time ago when we had originally gotten that filing that I think included all of these, that was provided by law enforcement or that was filed in the court system. It's been a while. I can't remember exactly where the text messages came from, but these are the exact same ones. And there were a lot of people who insisted they were not authentic. Lance Twigs has now proven that these very much are authentic. This is very much an actual interaction between himself and Tyler Robinson.
I had planned to grab my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering. And Tyler says, why did I do it? And Lance says, yeah. Tyler says, I had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything in the news about them finding it. We'll update you shortly, we'll update you by midnight. And then Lance says, all right, stay safe. How long have you been planning this?
Scroll down a little bit, please, Kimberly.
And Tyler replies, a bit over a week, I believe. I can get close to it, but there is a squad car parked right by it. I think they already swept that spot.
Now, I analyzed these months ago, and what I said back then is still true today, which is that Tyler Robinson is an awkward person. He communicates in an awkward way. We've seen it on body cam footage. We've seen it in a variety of settings with him, is that the way he communicates can be a bit peculiar. Lance Twigs didn't say, this doesn't seem like you. Why are you saying things in such a way? This very much was consistent with the way that Tyler Robinson communicated. So forensically, as odd as people seem to think these text messages are, I don't think there will be any problem authenticating who sent them, where they were sent from, and all of the other forensic evidence that comes with such strong evidence.
But I don't want to chance it.
We can scroll down to page 4 and continue.
Now we're going to briefly watch a video of Judge Graff reacting to the video of Charlie Kirk being shot. You're not going to see anything. All it's going to show is Judge Graff, but I do think that his reaction is important. I do think that the body language here is worth looking at. Now, you're already seeing that there's a little bit of discomfort. You can hear people cheering on the video. You can just barely hear the video at all. But he's moving back a little bit. When we're feeling uncomfortable, we try to gain distance from something that makes us uncomfortable. That becomes more significant in a second, but I want to show you this. Now, the actual shooting has not happened yet, but what you're seeing him touch his face, he's moving in his chair a bit, and these are positive things. We want a judge who can feel. We want somebody who actually has real reactions to all of this, because I think that that aids in better judgment. So the fact that he feels discomfort watching this, I actually think is a very important piece of this. I would be more uncomfortable as a citizen if you had somebody who had no reaction to this. So I think the fact that he is reacting to this, that he feels something about it, I think is important. And it's pretty obvious based on his body language what was happening on screen. You could see a very natural startle response. And then you saw him back his chair up automatically. Now, as I said before, when you are uncomfortable with something, you back up from it. I talk about people doing this all the time, actually, on the other side of things. When you have defendants and a judge is talking and they're getting mad at them, you see them back up from their tables. You see them scoot back. We try to gain distance when we're feeling uncomfortable. And anybody that has seen this video is going to feel uncomfortable watching it. But I do think that it's interesting that there are those body language reactions as he's watching this. I don't know if he's seen it before, actually, because his reaction is so strong. I do wonder if this is the first time he's actually watched it, or at least seen it from whatever angle they're showing it. As you can see, he automatically moved backward, but then re-engaged by moving forward again, just recovered from the shock of that very quickly. And it looks like right here he may be grinding his teeth, shows the real level of discomfort here. You see he's breathing heavier, he's blinking more. This should be extremely distressing and unsettling for anybody to watch.
And that concludes State's Exhibit 8. Mr. Sturgill, you may proceed.
Thank you, Judge.
And you can see what appears to be what I would judge as seriousness, stress on his face after watching this.
Concludes State's Exhibit 8.
I think anybody who is a normal functioning person is going to feel this way after watching that video. But what's important about this, and why I think this is significant body language wise, is it shows us that he actually feels something, that there is, which I think aids in good judgment. But at the same time, he doesn't overreact to it. We're not seeing somebody who is so affected by it that he can't do exactly what he needs to do. I think that this is exactly what we would want to see from a judge that is presiding over a case like this.
Mr. Sturgill, you may proceed.
Thank you, Judge. Is there any additional video that was collected by either?
All right, we'll go and start to wrap things up. Hopefully this is helping you better understand some of the forensic aspects of this case and why they're important. What we have seen so far is a tremendously strong case for the state. The interview with Lance Twigs combined with the text messages, hopefully that starts to get people a little more grounded in the reality of this. I know there's so many people that were denying that that was real, denying that there was the possibility those text messages were real, but everything that we're seeing today seems to suggest that they are actually authentic. They weren't made up by anybody. Lance Twigs was able to say these were real text messages. So hopefully that starts to put to rest some of the conspiracies around this.
I agree.
It probably won't, but I hope that it does. I'm going to continue to watch these hearings, and I'm going to continue to cover anything else that seems interesting related to this case. If you have any other thoughts about this, or if there's anything specific you want me to analyze, please let me know in the comments below. Last thing before we get finished up is I do want to remind you to like and subscribe if you want to see more content just like this. All right, thanks for watching.
Shout out to Dr. G. I did leave the link down in the description, so go check out his channel. Of course, subscribe to him. Support excellent content creators. I just really thought that was informative because as we've been watching this from Monday to today, I think most of us have realized that a lot of the conspiracies, a lot of the lies and false narratives, fan fiction that have been told for the last 10 months really are starting to, they crashed down on Monday. A lot of them really started taking on water on Monday. And now we are here toward the end of the week, and I've counted at least 20 false stories and narratives that we're going to talk about tomorrow on tomorrow's show that have come to light since then. And in a week, we've debunked 20 false narratives and probably more. I'm sure there's going to be more that I haven't even picked up on. Yeah, it's been 10 months. I mean, you do realize that he was killed on September 10th. So, I mean, we're almost a year out. And it's very possible that his kids will be in kindergarten by the time this is actually done. I mean, just something to think about, just something to put in your mind. Yeah, 10 months today. You're right. Yep, thank you. Good call. It's actually 10 months today. So it's just wild. So hopefully and prayerfully, all of this will come to some level of conclusion. But even yesterday, they made it sound like it would be a year before even the trial started. If he bonds us over to a trial and Tyler Robinson doesn't just fess up and come clean and say, look, I did it, and it goes to goes to trial, it could be a year. And that's how they made it sound like yesterday. It's sad 'cause I'm like, man, this is not a speedy trial at all by any means or measure, but we will definitely see for sure. Andrea is on. If y'all want, we'll bring Andrea in. Y'all know I love Andrea Burkhart. She does a great job of breaking this down. I want to hear what she has to say. And court is about, let me see where they are. They got about 12 minutes. We got about 12 minutes of hanging out with Andrea. If y'all want to hop in with her, the pretrial should have been months ago. No, I agree. That's the part I don't get, is how long they get to drag this stuff out is pretty sinister, in my opinion. It's crazy work. Like, well, what's the difference? Not trying to be funny, but what's the difference between the Carmelo Anthony trial and the Charlie Kirk trial? I mean, there's a lot of differences, yes. But Carmelo Anthony was a year. I mean, he was tried within 16 months, rather. He was tried within 16 months of when he killed Austin Metcalf to now being convicted. Like, what's taking so long? Great day. It just so. Anyway, let me bring Andrea in. Shout out to Andrea Burkhart. All right, let's see what she's got going on. What's she talking about, Andrea?
Be tracking pretty close to what I thought and what we talked about on the stream the night before. But they're not up yet. Not up yet. I did go check. Still haven't hit the docket. Not super uncommon when they're stuck in a long hearing like this. They went long yesterday, past their normal close of business. They've been going all day. Not really that surprising that it can take them a while to catch up on filings and things that happen during the middle of the week. But we don't have it, unfortunately, so we don't get to take a look at it right now. I'll continue to keep an eye on it, see if it pops up, and
I don't know what she's referring to.
Maybe we'll have it for our recap tonight. Guys, I'm going to keep the recap at 7:30 p.m. Pacific time, largely for consistency's sake and also just because we don't actually know how long it's going to take today. They have grand aspirations that it's going to be pretty quick. That's what we were told. It won't take very long. Yeah, not very long by lawyer standards. It could still easily mean by lunchtime, after lunchtime. We just don't know. So, just so we're not.
Okay, Andrea is kind of cleaning the traps. I'm gonna let her clean the traps. I got it real quick. I just got to let y'all know real quick. I didn't mention this to you all yesterday. I'll just go ahead and say this to the best live chat on the internet. Yesterday was a crazy day. I know you saw there's a lot of weird stuff happening yesterday in Whitaker Park. Well, President Firstborn had an accident yesterday. She was hit. And she's perfectly fine. So thank you so much. She's perfectly fine. But I'm dealing with the adjuster right now. And so I might have to take a couple of calls. I might have to step out to deal with that because the car is the car has seen better days, shall we say. So I'm trying to deal with that. And then also, I have a leak in my kitchen. So the plumber is on his way. So I got a lot of stuff going on. I got a claims adjuster coming and I got a plumber coming. So I'm going to try to dance between these two things, plus this live stream. We got to get this done. Well, look, we are 5 days in. I'm committed. So I'm trying to get this squared away. So anyway, I might put y'all, so just work with your brother, work with your boy, okay? So I'm going to put Andrea on. I got it real quick. The claims adjuster just called me, so I'm going to go ahead and grab this. But just want you to know exactly what's going on. So thank y'all so much. Here we go.
Christopher Bagley was our only percipient witness to the shooting. He's the only one that was there at the scene, able to describe what he saw, what he experienced, heard a gunshot. It's amazing to me that there should be any controversy in this. Really is kind of amazing that there would be any controversy about that because, of course, within seconds of Charlie being shot, hundreds, if not thousands of people present at UVU were on social media tweeting out, holy shit, Charlie got shot, texting their friends, Charlie got shot. Like, everybody knew Charlie got shot. Then the video's out. We're all seeing it whether we like it or not, if we are online on September the 10th. And we're all seeing and hearing Charlie get shot. Amazing that should be controversial, but Just speaks to the power of mind control, thought control, manipulation, gaslighting. Something that is really obvious to millions of people the moment it happens. If you can like call that into question, deny that, then you got some significant power over people's minds. Heard a gunshot, Mr. Bagley did. We knew it was a rifle and not a handgun because of that snap, crackle, pop, the bang pop. Bang versus a crack. Bang versus a crack. One of those issues that hard for me to like give that a ton of weight, right? Oh, a cop has ears, special ears, can distinguish between sounds, kind of thing. In a vacuum, like if we didn't all have this on video, hadn't all seen it for ourselves and stuff like that, probably real inclined to, you know, I'll take it, but I'm going to be skeptical. Going to be skeptical that the ears distinguish, but at the same time, I kind of know what he means. Really do. Go to the range, drive up. You can't see anything, but you can tell right away. Rifle range is over there. Pistols are over there. There is something different about the sound. We had some really interesting conversations about that and why that might be. Supersonic versus subsonic, but that's probably not it because the handgun is also generally going to be supersonic. But there is a difference. So the bang versus the crack. He heard a crack, made him think it was a rifle. He didn't realize that right away though because they found the abandoned holster.
That holster story.
Handgun, like a concealed pistol holster. And it was only when he saw that it had registered. Wait a minute, what I heard was a rifle.
I don't think that holster story is going to hold up. Nobody collected it. Nobody saw it. Nobody has it in evidence or a picture of it. No one's claiming it as their own. Like with the bullet that they found on top of the other building. Of course, one of the professionals said that this was their bullet because they checked their weapon. Okay, that makes sense. But the whole thing about that doggone holster, that makes no sense at all. I'm sorry. That is a big giant nothing burger story, in my opinion. I don't even understand what's the purpose of that story. Nobody knows where it is. People ask about it. Only one person recognized it or remembered it. I don't think it matters. In my opinion, I could be wrong. It could be the biggest giant piece of the puzzle that puts everything together. Maybe so, but I don't think so. What do y'all think? I know we were talking about supersonic versus subsonic, right? There's a clear difference between the sounds of a pistol, rifle, and a shotgun. Yeah, yeah, most certainly. After, right, what happened? No one was going to, but even then, am I missing it? Like, did anybody even say they knew they saw it? They even saw a picture of it? I don't even think anybody saw it. Because one person brings it up. And again, he could be right. It could be a pistol holster. It could have been it could have been something else. Who knows? We have no idea. Okay, they got the seal on. They got the seal cam is on, but nobody's doing anything yet. So we'll jump back over and finish up with Andrea. All right, Andrea, what you got, girl?
And that's what made him think, better check out the roof of the Low C Center, because he realizes there's a line of sight. It's a rifle. So he goes there to check it out. Finds a screwdriver on the roof. finds the impressions.
And they have
he
the screwdriver.
describes as the sniper pad. He describes it as showing impressions from the elbows, knees, and feet.
Normal time, yep.
We haven't seen it. He said the day photos weren't very good, but the night photos were better. Which I would expect. It's going to be more contrast with the lighting at the same time. That can be distorting, you know. So we haven't seen it yet, but definitely interested to see that. And then lastly, at the northeast corner of the building on the ground, he finds the shoe impression on the grass. Sees that, and so then he looks up and he sees scuff on the northeast corner of the building. He describes as the scuff. We also heard from Agent Hull, started hearing from Agent Hull. And from that, we heard there was at least one more bullet found at the scene. This is where we heard about the holster that was found. Learned that there was an autopsy. Not surprising. Dr. Guajardo performed the autopsy. We learned about the surveillance footage, and that it showed Tyler Robinson, who they are alleging to be Tyler Robinson, who they are alleging to be the same individual throughout the course of the day, on campus 4 times on September the 10th. Three times before and in the act of, the time of the shooting, and then later again that night. We learned that Tyler Robinson had an interaction with the police the night of September the 10th. And we learned that very obliquely, and not in a lot of detail, but that cell phone data helped them place Tyler in
cell
that
phone
location.
data.
This is a foreshadowing.
We already know.
Foreshadowing of a extremely valuable and probative source of information when it's available. Cell phone location data. It's data you can get from your phone, GPS, stuff like that. It's phone you can get from cloud servers, your iCloud backup, and stuff like that through different apps that track it, that data would get uploaded. So things like your searches, your Google Maps directions, stuff like that. Activity can be tracked and stored on the cloud. And then less valuable than the GPS, but still commonly used for investigation, the cell site location data that they get from the cell tower that tells them which phone is pinging off of this tower. And they can go in and
Oh, that's going to be that's going to be a struggle.
Preview. Just a very oblique little reference to cell data, putting him, being able to help them track his location, put him in a specific area. That is likely only going to get more substantial because it's going to benefit one side or the other. It will help the state put him there. It will help the defense show he's not. So almost certainly going to hear more about that as we get to trial. Moving on into day 2, we learned more about this bullet that was recovered at the scene, this other bullet. We learned that they accounted for it as having been cycled through one of the guns of one of the police officers on the scene. So they ruled it out as having any role to play in this shooting of Charlie Kirk. Some question about other guns at the scene. Not quite sure if it's been substantiated beyond there was another gun in the backpack, a backpack that was found at the scene. But the lost holster that we heard about, seems to be some conflict about whether it had a gun in it or not. We don't know yet how that's resolved. First, heard on day 2 about Tyler voluntarily surrendering to law enforcement, driven by his parents to turn himself in. And it was the defense who brought that up repeatedly, highlighted it, emphasized it. Tyler voluntarily surrendered. So we know the defense is leaning into that. They're not fighting that. They're not disputing it, not arguing it. We got to see finally the video of the surveillance footage. What we've seen so far was mostly the screenshots from it, with the exception of that one short bit from the roof that has the zooming and the highlighting, so that you can see more clearly. See the person come off the corner of the roof and start running towards the parking lot. So that part wasn't new, but I found it very helpful to see what they were describing as in the probable cause information as the gait, the awkward gait, the stiff gait. Kind of looks like somebody's got something shoved down his pants. To see that for ourselves, because the screenshots, of course, don't really make that clear what they mean. So we got to see it for ourselves, and now I get it. Now I get what they mean. Yeah, like a stiff leg that's being dragged, going up the stairs, one step, you know, not the normal. For me, anyway, I'm a like take 2 steps at the time kind of person, but I'm tall. So
Andrea said she likes to run up the stairs.
Was very very helpful, and then also the video from the earlier in the day that just is, yeah, the parking garage in particular. This is some very high quality video. You can see pretty clearly. On day 2, we also learned that the DNA on the towel and on the screwdriver were a match. Started to be a match to Lance and Tyler. Day 3 was our short day, Wednesday. It was aggravating because we got lots of argument, but we did still get some good quality information. We got the timeline now of the surrender and arrest, taking of Tyler into custody. 9:00 p.m. when he surrendered to Washington County Sheriff's Office. We learned a little bit more about the second bullet, the one that defense brought it up. David Holes, like, we accounted for it. It was cycled through the gun of one of the cops at the scene. Explained how that worked, by the way, too, because the rifle they keep in the cruiser ready condition, meaning no round chambered. When it's in the cruiser, no rounds. So then when you deploy and you take your gun, you have to chamber a round. But then when you put it back in the gun, you have to remove the round from the chamber. So can happen. You eject it. That's how they would know it was cycled. It would have the ejector marks on the casing of that cartridge. But dropped it, and that's going to create a lot of paperwork for that police officer. Nevertheless, they were able to account for it. Anyway, more detail about why it wasn't particularly probative in the opinion of the investigators, because the location of where it was found gave no line of sight to the tent where Charlie was shot, and it was 223, relatively small caliber, certainly small caliber for a long gun, and not consistent with what we are later to learn are the bullet fragments that were recovered during Charlie's autopsy. So that's most of what we got out of day 3. And then yesterday was the tying all the pieces together. see the person on the video, the morning video. Yeah, I think it's not rocket science to look at that, and looks a lot like Tyler. The ones during the time of the shooting, granted, not quite as clear. Not quite as clear. But otherwise, the only direct link we have is we have a screwdriver. We have him associated with the screwdriver and the towel. It's not nothing, but it's not really the strongest case for connection because, you know, you can donate household items to Goodwill. Other people can have them and use them.
You could do that,
On
sure.
the gun itself at this point. And we have the surrender, which is
Right.
certainly a thing. Definitely a thing you would consider. But any high profile incident is going to attract kooks. It's going to attract kooks. So haven't quite ruled out yet. This could just be some kook that surrendered himself. Possible. But yesterday was really about strengthening those connections between Tyler and
I have no idea what happened. It's always something. Let's bring Andrea back in here.
Textures is previewing that there are going to be technical challenges that the defense will raise. They'll argue it's not as easy as just interpreting a single source DNA profile. There's a lot more uncertainty surrounding that. So we already know that's coming. The defense has told us before, and Mr. McBride also. Making sure we understand there are going to be multi-day hearings about the validity of the science. We're going to hear from the studies. We're going to hear from the experts.
It's going to be wow.
So that,
I don't know.
that
I'm
will
looking.
be coming. I, for one, I can't wait. I really can't. The only thing.
All right. People are wondering. I'm over here looking. Court has not started yet. They're on the Utah seal, but that's all they have. They're on the Utah seal. So we're just waiting for it. So I don't know what the problem is, but thank you everybody who's already jumped in. Hit that like button saying what's up to your peoples and all that kind of good stuff. Thank you so much for it. Let's get popping. Let's get going. All right, we're going to finish up with Andrea until court starts.
They're doing next gen DNA analysis in the background, you know, where we can't see it because it's the investigative stuff. And we get to talk about that too. We get to learn about the emerging technologies because they're both exciting and scary. Really exciting, really scary. They open up so many doors and so many possibilities in terms of being able to develop evidence more precisely, which we all want. We don't want false positives. We don't want somebody being incorrectly identified by something. So the more precise we can be, the more helpful that's going to be. But we are going down a very slippery slope of the volume of personal, private, medical,
I knew it.
biographical information that is available now to people with the tools to pick up a few skin cells and develop your entire genetic code. And this is in a context, in a legal context, where your ability to kind of maintain control over your genetic privacy is real limited. because we don't control our shedding. We're getting into kind of this Gattaca. You guys remember
Gattaca is crazy.
Wasn't like the best movie ever. It's old.
Yeah.
I don't even remember when it came out now. But it was what's
a
his
long
name that
time
used to
ago.
be married to Uma Thurman?
Jude
Ethan
Law.
Hawke. Ethan Hawke.
Oh, Ethan Hawke was in it?
It's like this dystopic movie of where, like, I don't know, genetic purity is a thing, and this guy, the Ethan Hawke character, he's not actually genetically pure, but he's like trying to pass, and so he has to like super scrub himself, make sure he has like no loose hair and things like that, because yeah, that's the kind of thing everybody sheds throughout the day. And our legal structure as it exists right now, we just treat that as that's abandoned. You go out into the world, you leave DNA, you've abandoned it. So you no longer have any expectation of privacy.
Wow.
So anybody who can get a hold of it can do what they want.
Yeah, Jude Law was in the movie. I thought so.
If you don't have an expectation of privacy in it, then it can be captured, compiled, databased. This is potentially alarming stuff over the horizon. So that's like the only thing that would make me more excited than just knowing we're going to be having more DNA to talk about. And then we also got the tool marks. We got the voodoo, the tool mark voodoo.
Tool mark voodoo is
baffled
crazy.
About why we did a lot of exploring of the tool mark voodoo with respect to the conclusion that the ATF analyst made that was actually mostly beneficial to the defense. It's inconclusive. She can't say this came from the gun. She can't say it didn't, but she can't say it did.
That's crazy.
It's helpful to the defense. The one that wasn't helpful to the defense was her claim, I can say definitively that the Dremel tool that was found in Tyler Robinson's closet made the engravings on these different cartridges.
Right.
The one found at his house, test fire. The one that was fired inside the cartridge casing that was fired and was found inside the chamber of the rifle, and then the unfired cartridges that were inside the rifle. Dremel tool made all those. That seems to me where the logical point was to focus this criticism of the tool marks, because that's the damaging piece of evidence that you're trying to undermine. But for some reason, the defense didn't focus on that at all. Didn't focus on the Dremel tool at all. They focused on the jacket casing and just found that a little bit strange. Don't disagree with them in the 10,000 foot view that this is largely voodoo.
Voodoo is crazy.
Granted that we can all put things under a microscope, magnify it, blow it way up, look at it with our eyeballs. Doesn't take magic eyeballs to see, do these things look similar? The whole problem and the limitation of this this method is, what does similarity mean? How similar is significant? How dissimilar is significant? Because we know there is variability in the marks that a single gun will put on successive bullets, and there are variations, between firearms as well. They can be very, very similar marks coming from different guns, very different marks, and we don't really know enough about how similar is similar enough to say these came
Right.
from the same gun. We don't know if that's even possible. Frankly, we don't know. We don't know. There hasn't been enough foundational validity established to do that. And so because of that, we don't have the tools to be able to set standards for things like, even with something like fingerprints, it's still very similar. They call these feature comparison forensic methods. Many of them have been criticized for quite a long time. Fingerprints is a feature comparison method. You're looking at two different things, you're looking at their features, and you're comparing them to see if they're the same or not the same. At least with fingerprints, they have a standard. You got to find 7, you got to find 10, you got to find 14 points of comparison. Oh, looks like 14.
Camera's moving. Let's go. Green hearts in the chat when you can hear.
251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grunander, Ryan McBride, Lauren Hunt, David Sturgill for the state, and the county attorney Jeff Gray and Chris Ballard are also here.
Good morning.
Good morning, Your Honor. Kathy Nestor, Richard Novak, Stacy Visser, and Michael Burke here for Mr. Robinson, who's seated in the courtroom.
Good morning.
Good morning.
Mr. Robinson, good morning to you. And for the record, the court also recognizes the presence of victim representative Ms. Erica Kirk. Ms. Kirk, good morning to you as well. First, with respect to courtroom protocol to maintain security and decorum, any individual that exits the courtroom during proceedings will not be permitted to re-enter until recess. After recess, all counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and the still photographer. If both of you could please approach the lectern.
This is amazing. He does this every day. Shout out to him.
The court's purpose in this dialogue is to ensure clarity regarding the expectations.
I appreciate this every day.
Proceedings. Could you both please state your roles for today's hearing?
My role is to capture pool photography, still photos. My role is for video in accordance with the court decorum order.
And I apologize. Would you mind putting your names on the record?
Tess Crowley. Megan Thackeray with KSL.
Thank you. Have you both reviewed the court's standing decorum order?
Yes. Yes.
Do you understand the requirements set forth in that order as it applies to your activities today?
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No. No.
Do you anticipate any difficulty complying with the order?
No.
All right. Thank you both. Before we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone or electronic device in the courtroom may be addressed by the court. For those individuals who have a cell phone, I invite you to join me as I silence my cell phone to ensure that the proceedings today can proceed without distraction. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with this court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or of other visible reactions during the hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, and orderly, and faithful to the rights and dignity of every person involved. All right. My understanding is the parties wish to address an issue before we get started. Is that correct?
We may.
Mr. Novak.
Thank you, Your Honor, and good morning. I passed up to the court after providing copies of it to counsel for the state and counsel for the media, a single piece of paper. Does the court have that?
I do. Thank you, Mr. Novak.
Thank you, Your Honor. So every morning, this court has a colloquy with the camera operators about their ability to comply with this court's orders. And they acknowledge that they understand the order and that they can comply with it. And the court asks them if they have any problem with it, and they state to the court that they do not have a problem with it. We also spent many, many, many hours of court time addressing which exhibits will and will not be published through the electronic media. And this exhibit, the court ordered would not be published through the electronic media, and it was. And without belaboring the point, the court can imagine our concern that the media and the state who control this exhibit and the publication of this exhibit in the courtroom as per the court's orders failed to comply with this court's orders after all of the effort that we made and the court made to make sure that the court balanced everybody's rights, including the rights that we're concerned about, which are Mr. Robinson's. No doubt the counsel for the media and counsel for the state will say that it was a very, very brief mistake, that it was corrected as soon as they realized the error, but it's done. It's out there, it's photographed. I'm informed secondhand that if I want to buy this image and maybe even have it framed and put behind museum quality glass, I can do so and put it up in my office. Obviously, I'm not going to do that. But my point is, it doesn't matter how long the court's order was violated. When we live in an electronic world, it's done and it's permanent. And we just wanted the record to be clear that we're concerned that the court's orders have been violated, and they've been violated with respect to an order that was specifically designed to protect Mr. Robinson's right to a fair trial. And I don't want to belabor the point any further. I'm also not going to refer to the exhibit with any more specificity because it's not necessary.
Is there a requested remedy or potential sanction that you feel is warranted given the actions which you have outlined this morning?
I think that we would like to think, when I say we, I mean Mr. Robinson's counsel, about that. We have, as the court knows, repeatedly asked this court, moved this court, not to have electronic broadcast of this proceeding, of any of the proceedings, and specifically this proceeding. The court denied those motions and overruled our objections to the specific EMC requests. So I think it's a little premature, but I can represent to the court that we will suggest a remedy in advance of the next hearing.
Well, Mr. Novak, I appreciate that, but I would ask that if it is something that is concerning, that it be addressed immediately. So I'm not going to wait until this. I recognize and appreciate what you have described, and this was on my mind a lot last night as well.
Okay.
I don't want to sit on this. So I ask you respectfully to confer with your counsel and come up with that, because I want to address it. I agree. It is concerning, and it warrants examination and to be addressed immediately, especially as we have a little bit left of our preliminary hearing. So I want to give it the weight it is needed, and I don't disagree with you.
Then why don't we beg the court's indulgence? We don't need to empty the courtroom. We can go talk about what we think an appropriate measured sanction would be and we can bring that suggestion back to the court in a few minutes.
All right, well, before we do that, I want to turn to the state and to the media to address what you've addressed, and then obviously if there's a part two, then therefore.
And I appreciate the invitation, and I also appreciate the court's desire to address the consequences, if any, immediately.
Thank you, Mr.
I was not
Novak.
trying to delay it. I just think it's an issue which warrants some thought. The court has said it gave it some thought. We will have a suggestion very briefly.
Thank you. Turning to the state.
Thank you, Your Honor. I think at the outset it's important to recognize that everyone's doing their best here. The court is, I know the clerks are, I think the media is, we certainly are, and the defense is. This issue came up in the context of an examination of a witness. One exhibit was published. Before the exhibit at issue was also brought onto the screen, I explained what we were going to do, and then the exhibit was brought onto the screen. I reviewed the video last night. The camera captured this for approximately 2 seconds. The camera operator, I think acting in diligence and appropriateness, immediately panned as soon as she realized that there was a new exhibit on the screen. The court took it down as soon as they realized that an exhibit was on the screen. I immediately instructed my paralegal to take it down, and it was. Defense, I think everyone involved here made quick and appropriate efforts as soon as they realized a mistake had been made to remedy and mitigate that issue. As I explained what I was what we were going to do, defense counsel did not object as that happened. And the reason I bring that up is because of the requirement for timely objections. Moreover, I do want to say this exhibit was read into the record. It was allowed to be read into the record earlier. It is also in an earlier pleading, which is the information. This portion of that exhibit, I understand, is in the information. And it is largely cumulative of Exhibit 16 and 16.1, which were previously admitted into evidence and published to the media. Finally, we are going to be dealing with a lot of publicity when it comes to media coverage, and I think that's really where the remedy is going to be addressed. I understand there may be a remedy that can be fashioned today to prevent this kind of thing going forward or going on in the future in this hearing, but I think ultimately that's where this will be addressed. Any other questions from me, Your Honor?
Well, not at this time. I will afford you the opportunity, obviously, to respond when the defense comes back. I want to weigh this and taking in consideration, and I find your representations to be accurate as to what occurred. I believe that I noticed it and asked for it to be taken down because I have a live stream on my screen for that very purpose. And the sequence, I believe I made note, and if I'm wrong, please correct me. It's been a long 4 past days, but that's the only addition that I find to the representation. And certainly, Mr. Novak, feel free to correct it if you believe the sequence was any different. I just want to make sure a clear record is being made of what happened in order for whatever happens next to be appropriate and proportional to the actions that occurred.
No, and that's consistent with my memory, and I also reviewed the video, the live stream as well in preparation for this issue today. So that's exactly what I think happened. From my perspective, examining the witness, I did not have a view of what was being published to the public and the media, and so I think the court immediately, as soon as it recognized that, brought that to everyone's attention.
Thank you, Mr. McBride. To the media.
Good morning, Your Honor.
Good morning.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point. But here's how I understand it. There's 2 exhibits at issue. Those exhibits were used yesterday in part because the juxtaposition of those 2 exhibits might have provided some sort of benefit to the court. The first of those exhibits was asked to be published through all three of the court's phases. The court said it will be admitted into evidence, be shown in the courtroom, it will not be shown on the cameras. That happened about 3 hours into the hearing. That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the runtime yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that three-step process. In that case, the court said that that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. Examination on that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit, and recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end of it. I think the 2 seconds is about right. I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire, and we are trying to place as many nets as we can, and all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live screen, someone can screenshot it, and like Mr. Novak said, if they want to put that for sale on the internet, then they can.
Anybody selling nothing?
Working together to ensure that even small mistakes like that don't happen is critical. And the media has the media coalition that are given the opportunity and the benefit of being able to be here to run cameras and to take photographs have complete buy-in on that point. There are, of course, people out there watching a live stream that are not part of our coalition that we can't control, and that's why it's so important that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word, of that exhibit is contained in a search warrant, in this case, that was initially filed on September 17th. This is in the 4th District, but in a different court. Was held for 6 months, as search warrants often are, but then on March 16th, March 17th, was released in full. On page 7 of that search warrant is the full text of this exhibit. I don't want to suggest that anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen, but since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for the purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image of the exhibit itself, but the full text is already in the public sphere, has been reported on, and is out there. I only want to reinforce, to close, the recognition that the media, our coalition, I, as an attorney for that coalition, have an obligation to make sure that mistakes don't get made. And in this case, even though I believe that the camera operator didn't act in violation of the court's decorum order, didn't do something that was forbidden by that there was an order that said, don't publish this exhibit. And because it flashed on the screen when the camera operator was filming that screen, that did happen. The media is fully bought in. I, as one of the attorneys and the other attorneys for the media coalition, are fully bought in on a goal to make sure that this kind of thing doesn't happen. Of course, I understand Mr. Novak and the defense's need to make a record and make an objection, and I also recognize and appreciate and understand the court's role in trying to make sure it imposes whatever sort of direction, caution, sanction, response that it believes is needed to make sure that its orders are recognized and adhered to. And I want the court to know that we will understand that and will comply with whatever it is that the court orders.
Thank you. Anything further before we break? Mr. Novak?
Wait, how are we breaking already?
Okay. Well,
The court wants a break.
I want to review this. I'm sure there is a stream out there. I want to look at it again in order to appreciate the full effect and exposure. I remember it, but given the nature of this and trying to weigh the constitutional rights of all parties, I want to be thorough and look at it exactly. So as we move forward, as I evaluate what's being requested by the parties, that I am at the level of knowledge and because what it is, it was on screen. I want to look at it, how long, what exactly was on screen, and in order to be at the point of saying, okay.
I ain't do
I
it.
fully understand. I mean, I was here, I saw it, I noticed it on the screen, but again, I want to take that extra 2 minutes to review that.
I am not suggesting that we rush through this at all. I just wanted the court to understand that our request for the remedy and the sanction, we are prepared to share that with the court, but we can certainly wait until the court has had an opportunity to review whatever the court thinks it needs to review.
Oh my gosh.
The permanence of this violation of the court order is a different issue from how long it took to correct the violation. It's a permanent consequence. In other words, that image is out there forever and ever in violation of the court's order.
Now I want to know the
No matter
image
what,
now. What is the image?
Actions the court, the state, and the media took to remedy it, because that's the technological world we live in. So that's my response, if I may, to the arguments. But we can hold our suggestion until the court's ready for it.
All right. If the parties feel it'd be helpful to confer while the court is reviewing it, you may, just so that if you choose to, I encourage it. If you don't, I respect that. A court's going to take about 5 minutes. Again, I just want to review it, to be brought up to full speed and just to have it freshly in my mind.
I'm going to make one more point, if I may, and that is, this is not the first time that this has happened. We had earlier proceedings in this case where the cameras depicted images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion, if I may. Thank you.
Let me tell you how to do your
Before the
job.
court takes a 5-minute recess and to review this, does any party need the benefit of the record based off
I need the benefit of the record.
dialogue between me and Mr. Novak? All right, not seeing any party respond. The court's in recess. We'll come back at 9:45. Court is in a brief recess.
Oh my gosh, man. Oh my gosh. This trial is going to be the song that never ends. Oh my gosh. Hey, so real quick. I don't know if y'all know, but Brian Harpole is suing Candace Owens, right? And we know that. And I remembered this morning, shout out to Heather, sent me a link about Brian Harpole having some issues with the judge. One second. I had a joke for y'all, but I gotta attend to something. 1 second. Un momento, por favor. All right, I'm back up in this building, y'all. We back up in here causing trouble. Shout out to y'all. If you all are wondering, I told you all earlier, cut that music off. We got a whole bunch of stuff going on today. I got claims adjuster coming to look at a car. I got the plumber over here fixing a leaking faucet in my house. We got a lot of drama going on over here at Whitaker Park, but we're going to get it done. We're going to get done with this trial too. So shout out to y'all. Thank you so much. I want to say thank you so much to the very kind support. Thank you, SC. Joshua Carr is type 1 diabetic and his insulin pump is paired to his phone. He couldn't even take in his phone in yesterday, regardless of medical necessity. Wow. Joshua Carr did a live last night about the inside of the courtroom. Y'all should check it out. Good info. Okay. I will definitely check it out. I saw his video. I didn't have a chance to watch it. Life just be life and sometimes. Okay. So here's a quick joke. All right. Brian Harpo is suing Candace Owens. Y'all know that. And Candace Owens, apparently, because of the attorney that she selected to represent her in Brian Harpo's case, has sued every attorney in the district. So every judge in the district. So every judge has had to recuse him or herself because of this. This is the craziest story. It's crazy. Shout out to Heather for telling me about it. So in honor of that, I've remembered I actually have on my store, I actually have a bumper sticker. It's called Honk If You're Suing Candace Owens. So y'all go grab yourself a bumper sticker. Get on over there and grab yourself a bumper sticker. Honk if you're suing Candace Owens. Because everybody else is doing it. All the cool kids are suing her. You might as well. I probably need to make one, honk if you've been sued by Candace Owens. Maybe that's another one I need to make. Like, get in there, get yourself one. Get yourself a T-shirt. Shout out. There we go. Chrissy in the building. Get yourself a T-shirt. All that kind of stuff. We got Edie in the building modeling our stuff. Oh, and by the way, if you do pick up one, send me a picture. You can be the model. Because that's crazy work. That's why we do it, right? Or you could be the obscure YouTuber. We got Monique up in the building, all that kind of stuff. Grab yourself a hat, all that stuff. Do it. Help a brother out. Anyway, I just dropped the link down in the description. And honk the horn if you're suing Candace Owens. And let me know, should I get one honk the horn if you're being sued by Candace Owens? I mean, that's crazy. So her attorney has sued so many judges that all the judges in the district had to recuse themselves because they have some kind of interaction with her. And it's a conflict of interest. That is the craziest strategy I've ever seen in my life. Honk if Candace Owens annoys you. That would be, you know what that would be? That would be sound pollution. The only reason we can't do that bumper sticker is it would be sound pollution. And so many people would be honking their horns. It would be so annoying that, I mean, there would be no healing in the world. There would be no healing in the world because of the sound pollution. I mean, that's all we can do. Because this is what it would sound like. This is like the world would, this is all you would hear all the time would be people honking their horns because of this. Where's my horn? Oh, there it is. This is all you'd hear. All day long. It would just be all over the place. It would be crazy. It'd be bananas. All right. I mean, well, she's now Russian, so, I mean, there's true. That's some crazy work, y'all. All right, let's see if Judge Graff is back. Oh, matter of fact, they are. Shout out. Right on time. Oh, the camera guy's moving. What is the world? Wow, we're getting like hair analysis. I'm feeling oppressed because I'm bald, so I feel very, very offended by this. Why are you showing me your hair? I'm offended. Look, man, this is very disappointing to bald people. That thing is showing like every hair follicle, dude. Great day. What kind of camera is that? 19K? What is that? I mean, we are like we can see his thoughts. This camera angle is intense, man. This is the camera they needed to take a picture of Tyler Robinson. This case would have been solved already. I mean, we see like liver spots. I mean, we seen everything. Receding hairline, the whole nine. What in the world? That was some serious 24K camera angle. What in the world? I need that camera. What do you say he needs? Dang, man. Lotion on his forehead. Dang, bro. That's kind of harsh, man. That's harsh, man. We could see his thoughts, man. Look, couldn't you tell me you couldn't see that man's thoughts? You know it. Jailhouse water with that. That's another good question. I did think about that. Like the water quality in jail has got to be terrible. All hair, no thoughts. Y'all are wild. Right. I was thinking that. I was like, man, if that dude had lights, we would have seen it in 4K. He would have never been able to live that down. Never. Oh man, that's terrible. There'd been no way to live that down. Like, you just gave up on life, bruh. What's that? Milklex? Y'all are wild, man. What we got here? Y'all are crazy, man. Why y'all like this early in the morning? Jay Witt. Look at Janae's comment about the bumper sticker. Oh gosh. Janae, what's your comment? These comments are moving fast and furious over here. I see this one right here. Janae, just put the comment again. I promise that, like, put it in there, put like some asterisks by it or something so I can see it. That actually was kind of funny though. Okay. Jay Witt. Comment about the bumper sticker. Okay. Janae, just put a comment again. Help your brother out. But he didn't have any dandruff though. That is a good point. I mean, I thought it was like okay, I thought they were ready to go. They were moving the cameras. They faked us out. Yeah, please hit the like button, my good people. Thank y'all so much for everybody who's tapped in with us today. This is going to be a good one. And if you're just jumping in at the current moment, Judge Graft is reviewing some piece of data, some video image that was shared, that was able to get out, that shouldn't have been shared. It shouldn't have gotten out. It was in the wild. It's broke containment. So he's checking it out to see what he's going to make a decision on. And we're just commenting about whoever keeps stepping in front of the camera because we can see their thoughts. Like, that's how that camera is intense. Somebody who knows how to do memes is to do a Staying Alive with Candace and George dancing in the cemetery. Oh my gosh, with money growing on trees. Somebody will do it. Somebody will do it. Send it over to Fax Me. Fax Me will do it for sure. Steven will definitely do it. That guy is a beast with that. Well, 62 people. Help a brother out. Help a brother out. Hit that like button. The like button does not cost you anything. It helps out so much. And then also comment. Between likes and commenting. Matter of fact, I'll probably have to do a show on that again. I did a show on that in the past. Like, of course, super chats are amazing. All that kind of stuff is fantastic. But if you just like, how can I help out the best way? What did Janae say? I'd buy one for every car we have in our kids and grandkids. Sell it 15 right away. Well, go grab them. Go grab them. But, you know, when you hit the like button, that helps out a whole lot. And you comment and you share the video. All those things are very, very beneficial. Very beneficial. Being a part of the live chat, just commenting on the live chat is super, super helpful. And none of those things cost you anything. So they're very helpful. They help us out on this end because then it lets YouTube know that there's really, truly, because this is the thing. There's 168 people on YouTube, 15 on X watching. And if everybody commented right now, there would be better than 175 comments in a minute. And that tells YouTube like something's going on, that Jason's doing something over here that people enjoy. So what is he doing? Oh, he's doing the Tyler Robinson case. So anybody who's looking to talk about the Tyler Robinson case, they will be shared my content because they'll say, hey, Jason's got some stuff going on over there because people over there engaging. We got, you know, DJW music is popping off over there. We got Rosie's popping off, all that kind of stuff. Jason must be doing something. So the more you all engage in the best live chat, the more it tells YouTube that Jason is doing what YouTube wants me to do, which is to engage and keep you all entertained. You know, insert the Maximus, are you not entertained? Comment right here, right? It is. So, and shout out to the new subscribers, y'all. Shout out to everybody. I'll have to do a show tomorrow when I do my 20 plus lies that Candace has told that have been debunked episode tomorrow evening. I'll go over who I am because a lot of people, we got a lot of new subscribers, a lot of new people to the family. Y'all might not know who I am. So I might go over and give you a little quick rundown on who is Jason. I haven't done that in a while. Now I will introduce you to my near cousin, producer Jason. Every now and then we got producer Jason pops up in the building. So there's that as well. That looks pretty good. That came out pretty good today, Jason. That one came out pretty well. Uh-oh, look, hey, come on, it's an honor. It's an honor. DJ said, look, I actually don't subscribe to anybody. So you are the first. Well, shout out, brother. Thank you so much. I appreciate you popping in. If you ever want to, I know that you are in, if I'm understanding you correctly, you are in the legal field, shoot me an email. We can maybe we'll have you come on and talk about this, straighten me out, pre-K law student that I am. Jack from TPUSA said that we're seeing grainy footage, but in the courtroom is high definition. That's another thing that I think people need to factor in. There's a lot of, and thank you so much, grounded based. That's something else that a lot of people are missing. Like we're seeing this through another camera. I mean, we got this 19K camera they got here, but we're seeing this through a lot of different means because some people are watching it through their phones. Some people are watching it on their televisions, on their tablets, and it's such like that. There's a lot of transition, a lot of it's being shared through a lot of different mediums before it hits your eyeballs. So yeah, there's a lot of things that can go, I don't want to say go wrong, but make something look not as good as it and as crisp to us, but it is probably perfect for the people in the courtroom. I agree. Oh, I don't think, oh no, there's no way court's going to end by lunchtime. Give it up, Graf. You're going to be here till 3:30. You're going to be here today, my dude. You're not, now, maybe they're going to end before 5 on Mountain Time. I'll give you that. I'll give you that, but there's no way. Novak is going to get up there and he is going to, Novak rhymes is Latin for talks a lot. So he's going to get up there and he is going to bloviate and he's just going to talk. I promise you. I promise you, he's just going to talk. He's just going to get up there and be yapping. He's just going to be yapping. All right. So the auto adjuster is coming to look at the car. All right. There we go. All right. I have to show you all that picture, man. That car, I was like, man, I like that little car too, man. Hold on, where's that picture at? I was like, man. But as long as my baby is okay, I'm fine with it. But man, I was a little bit disappointed. I was a little sad. Where's that picture of that car? I don't know what I did with it. What did I do with it? I sent it to my wife, and I don't know what I did with it. Anyway, yeah, man. But as long as she was fine with it, she handled it very well. I was very proud. I was very proud of her. I'm a little less proud of this court case, though. Why y'all taking so long? What are we doing over here, people? What are we doing? You said Jason. What'd you say? I didn't know that first either. It's just Jason, producer, editor Jason. There's host Jason. Periodically, there's Jason X that hasn't shown up in a while. That's my anti-Umar Johnson. Jason X. There's producer Jason, editor Jason. Whatever Jason I need to make a blame for something, that'll be the Jason that shows up. Oh, so here's the picture right here. All right, real quick. All right, so there's my car, my baby's car. So I don't know. I don't think it's gonna make it, man. I don't know. Let's see what the adjuster says, but it is, shall we say, seen better days. So I don't know who Jason Whitlock is. That guy. So like the bumper is shot. I mean, it is broken. It is, that lady just cleaned it. But this quarter panel is crumpled right here. They might. Oh, and there's a water reservoir right here that is trashed. I mean, it didn't break it, but it is like off of the frame. So it's kind of like dangling. So that can be fixed. Hey, look, I love the car. It's a great little car. And I thought it was excellent for me. If they fix it and get it back to me, I'll take it. Or they might give me, some bread for it. Give me some bread in my pocket. I'll take that too. I'll just go get her another one. So, but I'm just glad my baby's okay. So it doesn't matter. I mean, all things being said, I'm just happy my girl's okay. Oh no, it wasn't her fault at all. That was the other lady's fault. But anyway, that was it. So what we got here? Oh, really? You don't think it's that bad? No, I don't think it bent the axle. No, I drove it yesterday to the mechanic. I drove it from the place, and I mean, it just there's a lot. Maybe it does look worse than let me look at it. Maybe I'm making it sound worse. A little Bondo, smooth it out. No, we're not Bondoing my car. No. Like, the bumper's going to be replaced, going to have to be totally replaced. Like I said, there's a water reservoir. This is crumpled. I mean, I got you. It might not be as bad as it looks to me. I was actually surprised the headlights were not damaged. I don't even know how that even, I skipped the headlight. Like I didn't break the headlight. So, okay, buff it out. Y'all are crazy, man. Somebody say Gorilla Glue. See, that's exactly why we don't have nice things, people. That's exactly why. That's exactly why. Man, you about to pay more than Carmelo did for his deal. Well, I'm not paying anything. I didn't do anything. My baby did duct tape. Why are y'all like this? See, that's why, it's people like this. This is 100% why we can't have nice things. See? No Gorilla Glue. None whatsoever. This rascal says zip ties. See, that's exactly why I'm about to put the whole live chat in timeout. These rascals are talking about zip ties. See? When you say, when you look up at night and say, why won't the aliens talk to us? Why won't the aliens be our friends? This is exactly why. Because we're doing stuff like this. Zip tying, hot glue. I'm a former school teacher. School teachers believe in hot glue guns. We believe in hot glue guns. There's certain things since I've retired from teaching that I've never thought about again. But one thing for sure is I still have 2 hot glue guns right in my garage. We believe in them. And the answer is no, we're not going to hot glue the car. What's wrong with you people, man? See, that's exactly why the aliens will not talk to us. That's exactly why. The Red Green Show? What is that? You never watched the Red Green Show? What is the Red Green Show? Oh man, we believe in it. Now, I will say they've stepped the game up of hot glue guns. I didn't realize that, they got wireless hot glue guns now and stuff like that. I'm like, yo, if I was a teacher today, I would definitely unequivocally be rocking a wireless hot glue gun. That thing just looks savage. Ain't got nothing to hot glue. Ain't got nothing to hot glue at all. But I'm telling you, if I did, I would. Oh, Jason, YouTube red green. What is this red green? What are y'all talking about? Are y'all okay? Hold on, let me find this. YouTube red green. What is this? It better be better than y'all talking about some Gorilla Glue in my car. What is it? YouTube red green? What is this thing? Yeah. I got a bad feeling, man. Red Green Show full episode. What is this? Red Green TV? Is that what it is? The man's got duct tape in his hand. I already knew something. The wheels on the bus was falling off. Why he got duct tape? What are y'all doing? Y'all people are. I feel like Judge Graff now. He got a lot of viewers too. Oh, he's live. What is he doing live? Y'all are wild, man. Bungee cords is crazy. Why is it filmed like that? This is a very interesting way it's filmed. It looks like something from the 70s, man. Just looking at it, like what camera are they using? This looks like straight from the 70s. All right, I need to look into this. Yeah. Red Green TV. That right there. That's what got me right there. I saw that duct tape right there. I said, y'all wild, man. Is that what it is? Okay, it is a Canadian show. Okay. That's what it is. Let me see if Judge Graff is back. He is not back. Let me put this in my ears so I can hear it. Okay. This dude says saran wrap. See? That's exactly why. Mommy, why won't the aliens talk to us? Because people think that you should saran wrap a car. That's why. That's why they won't talk to us. Wait. A deer ran into me and cracked my bumper and fixed it with duct tape. I just can't do it to my kid. I mean, she broke this part. And the bad thing is that her car was much taller. And this is a downside of the height disparity, the height discrepancies that we have with our cars. Because she had a very big SUV. And when I looked at her car, it was just the lower bumper of her car. So if you can imagine just the lower bumper of her car. So that shows you how low my car is. This car is compared to her bumper. So that's just one of the problems, I think. But most people have much taller cars. I just like small cars. I don't know why. Because I'm not really that tall. Maybe that's why. I also like hatchbacks too. So like all my vehicles are hatchbacks. What do we have? They're still. Now, Judge Graff, now you told us you was going to be back over here, man. You are playing with our emotions, sir. It's only a flesh wound. Why are y'all doing this, man? Sharpie can cover the scratches. So clearly y'all just wilding out over here today. That's what it is. We've been doing this for 5 days. This is the 5th day, and I guess y'all just like the wheels on the bus falling off, right? Okay, I got you. That's fine. I'm going to work with y'all. I'm going to work with you. $25 a bag of what? I cannot. There is absolutely no way they're going to get done with this trial today. And definitely not before lunch. You can give that up. It's just not going to happen. Okay, now I do see movement. Uh-oh, we got movement. What we got? Uh-oh, let's see Judge Graff's got to say.
All parties, and where we left off is the court took a recess to review the video. And I appreciate the patience of the parties as well as everyone in attendance when it comes to constitutional matters and balancing constitutional rights and transparency. This court will take the necessary time to make sure it's given the weight it deserves, and it is deserving of every moment that has been spent. Mr. Novak, turning to you.
I told you, Novak is back.
Perhaps before you begin, let me go ahead and make a record of what I noted that is at issue. And after I put this on the record, certainly if either side wishes to be heard about the court's understanding, I welcome your comments. Exhibit 24 was displayed on the monitor visible to the media camera. Exhibit 16 was displayed on all monitors and appeared on the live stream for approximately 3.5 seconds. The camera operator redirected camera before any party called attention to the display of Exhibit 16. Approximately 16 seconds later, the court observed the image and stated, "Let me stop you, Mr. McBride. I'm not sure. Is this being broadcast?" Mr. McBride responded, "Let's take that down." The full text of Exhibit 16 had previously been made public through a search warrant that was publicly available on or before April 2026. The portion displayed on the monitors did not contain the full note and consisted of approximately 78 words. Approximately 15 of those words were included in the information filed on September 16th, 2026. In addition, the full note was read into the record during the preliminary hearing. The court previously ordered that Exhibit 16 be admitted into evidence and permitted its display within the courtroom, but prohibited its publication through the camera used for the live stream. And that concludes the findings of the court as it relates to this issue. Do the parties wish to be heard before we go into what you're requesting about the record on what occurred?
Your Honor, your recitation is accurate. My earlier comments were based on my memory of reviewing this last night. In the recess, I reviewed the feed again, and what you have said today is accurate.
Thank you. Mr. Novak, any?
No, Your Honor, I don't take issue with the court's factual summary.
All right. Turning to you, Mr. Novak.
Thank you, Your Honor. We're going to renew our request to exclude all electronic media coverage from all future proceedings. That was our motion docketed at number 305, and that included video cameras, still photography, and audio. This is the second time that the court's orders concerning the scope of electronic media coverage have been violated. I'm a baseball fan, and I just don't think the court needs to wait for the third strike. 2 strikes is enough. If I may, the alternative remedy, which we think is not wholly adequate, which is why we think it's an alternative and a less desirable alternative, is for this court to both reverse its prior order authorizing electronic media coverage of today's hearing, which we had previously filed an objection to after the court, I would say preliminarily granted the requests for today. That was sort of the chain of events. And that the court proactively preclude electronic media coverage at the last day of the preliminary hearing, which will be September 1st. Now, I understand that there has not yet been a request for electronic media coverage for September 1st, but there is no doubt that there will be, just as this court previously observed that it wasn't prepared to preclude electronic media coverage at the preliminary hearing because there had not been any requests. There were requests, and those that were timely were all granted. The court denied one request because it was not timely for one particular day. So I guess the way it would be is any request for electronic media coverage of September 1st will be denied because that's the appropriate sanction for what happened yesterday. The fact that the content of the exhibit was previously summarized by the state in certain documents which became public because the state didn't take any actions to seal them beyond the 6-month period. The fact that the contents of the exhibit were read in open court is not the issue. The issue is when the court issues an order, everybody must comply with it, and there are reasons for the order. And the reasons, as this court stated, are to protect Mr. Robinson's right to a fair trial. So no doubt that the court balanced those prior ways in which the content of this exhibit had already been disclosed when the court decided that there would not be electronic media coverage. That's a fact that we have all known of that exhibit. That's a fact that we've all been aware of as we've gone along. So to summarize, and then I will stop because I know we still have a witness here, and of course the court needs to hear from the state and counsel for the media, I suspect, is we would like the court to reconsider its order denying motion 305 and grant it for the balance of all of the proceedings in this matter, or as an alternative, the court prohibit any further electronic media coverage of the preliminary hearing, which includes September 1st.
Thank you, Mr. Novak.
Thank you very much.
Turning to the state and then to the media.
Yes, Your Honor, as to the remedy, we've heard of instances where the media has been able to delay publication of the recordings of the proceedings. We've heard of instances where that has been a short delay of like 30 seconds. I've talked to the media attorney about this, and they do not have the capability to do that right now. My suggestion would be for future proceedings to order the media to look into that capability.
A delay is perfect.
That would be a remedy that perhaps could be used in the future. I think that would be a satisfactory remedy to avoid this type of thing in the future. As to the other remedies requested, we have one witness. The final witness, well, the defense has one witness. That witness is a ATF DNA forensic biologist. And I assume that the exhibits that will be admitted through her will be of that nature. We've already, in fact, admitted the report that she is going to be testifying to. The reports, I should say, that's exhibits 30 and I believe 34. And so I don't think we have, and those have already been published, I don't think we have the same risks or, I'll just say risks with her testimony as we do with some of this other evidence that has already been admitted.
Thank you. To the media.
In a proceeding like this, the parties in the court and the media are working together to learn and to refine their processes. I hear Mr. Novak's remarks about challenges that we've run into in the past. I recall, it hasn't been that long ago, a time when the camera was placed in a location in the courtroom that was causing challenges. The court moved it. When there were challenges with aspects of the court's ruling, the court reiterated those, and those processes improved. We are getting better at this. Media is on board and recognizes the court's obligation and its significant efforts to balance the interests here. In light of the court's ruling, including its recognition that the media operator in this case beat almost all of us to the punch, right? And saw what was happening on the screen and moved away as quickly as they could. We believe that the procedures that the court currently has in place, even if they don't, every moment of every hearing deliver the result that we are intending to deliver. Those processes are working. I don't believe that a further adjustment, much less a sanction, much less a revisitation of something that says let's keep every photographer, every camera out of this courtroom for every proceeding. In light of the court's well-reasoned and exhaustive rulings after a long briefing on all of this, the court is currently balancing these interests correctly, and we therefore ask the court to allow the parties to recognize that the time we're dedicating this morning represents a reiteration of the importance of these principles. The media and the parties all recognize that, and we'll continue to endeavor at all times to do all that we can to ensure that those are adhered to, and let the parties go forward under the current procedures without further order or sanction by the court.
Thank you. Any further arguments before the court issues its ruling?
No, but thank you for the opportunity.
Thank you. And just updating my notes as I'm intending to issue this ruling right now. I'm just making sure that I'm capturing all the points made in the argument right now.
What is Judge Graff doing? Y'all get Judge Graff back. Come on now, sir. Y'all got Judge Graff over there looking serious. He is really typing. He is not playing. He is typing that thing and he means business. I think that the delay is probably the best way to handle this problem. Just have it delayed. A 10-second delay is perfect. And they can do that on the stream side.
All right.
All right, let's see what he's got.
I'm almost done. I appreciate the party's patience. This issue rises to the level that necessitates great care. And as my practice, I don't like to rush or make snap decisions. And I want to give this the full analysis that it's due. So thank you again for your patience. All right. Court will issue its ruling on the request by defense. The constitutional rights of Mr. Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, the court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense that this constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied. The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions. With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. The court reserves this sanction as it relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, that request has been filed and all the deadlines which the court has imposed in regards to the MC filing are in place, if motions are filed, the court will entertain motions in brief argument ahead of the September 1st hearing and address it at that time. This is the ruling of the court. Thank you. Turning to the defense, if you wish, you may call your next witness.
Judge, we would like the benefit of the record before we start taking evidence today.
Yes, Mr. Grenander, and I'll allow all parties, given the ruling of the court, briefly.
And I'll be brief, Judge. And this is in relation to the continued taking of evidence today. And I'll start my statement, Judge, with something that was very insightful that you said the other day. You mentioned, and I quote, "Sometimes you need to take time to save time," close quote. And so that's my purpose for standing up here this morning. We have spent the better part of a day, a little over 5 hours, I believe, hearing from witnesses that the defense has called at this preliminary hearing. And no doubt the defense is entitled to call witnesses at a preliminary hearing as allowed by the rules. But I think it's important that the court remind all parties about the purpose of this hearing. This is a probable cause hearing, as Your Honor has repeatedly stated. The defense has invoked the term reliability many times, and the court, frankly, has found the evidence that's been admitted, the testimony. As a gatekeeper, the court has found it reliable. It's been presented. The exhibits have been found reliable. So any questions of additional reliability are really questions of credibility of the witness and weighing of the evidence. And that is not really what this court engages in at the probable cause standard. And so this is all couched in the context of a likely forthcoming standing objection that the state may lodge if the testimony is long and drawn out and exceeds the scope of the preliminary hearing, gets into areas of a 702 hearing, possibly even trial. We will lodge this objection, but I wanted to just simply state the authority, Judge, behind our objection if we do make that. As your court is well aware, the magistrate at this stage of the case must view the evidence in the light most favorable to the prosecution. And that's cited to in a number of Utah cases, to include State v. Schmidt. Schmidt continues, this means that when reasonable inferences from the evidence cut both for and against the state's case, the magistrate lacks the discretion to choose between them and must leave such a determination to the fact finder at trial. A few other cases I would like to refer the court to. State v. Pledger, which is a Utah 1995 Supreme Court case. Speaking of this standard, the court says, the standard bars the magistrate from requiring the prosecution to address or even eliminate alternative inferences that could be drawn from the evidence in favor of the defense. So even assuming the defense scores points today in calling these witnesses, again, the court cannot really weigh those in favor of the defense. State v. Hester, which is a Utah Court of Appeals case 2000, where there is conflicting evidence, quote, the magistrate may not sift or weigh the evidence, but must leave those tasks to the fact finder at trial. Of course, we're not at trial yet. State v. Virgin, a Utah 2006 Supreme Court case, indicates that a magistrate may only disregard evidence at a preliminary hearing if it is, quote, so contradictory, inconsistent, or unbelievable that it is unreasonable to base belief of an element of the prosecution's claim on that evidence. There's a State v. Drozbecki case, which is a Utah Court of Appeals case 2010. Magistrates may only disregard or discredit evidence that is wholly lacking and incapable of creating a reasonable inference regarding a portion of the prosecution's claim, but must leave all the weighing of credible but conflicting evidence to the trier of fact. And finally, State v. Lopez, a Utah 2020 Supreme Court case. Speaking of this probable cause standard at a preliminary hearing, the court said, under this low bar, it may be difficult for the defense to overcome a prima facie showing of probable cause. Even an alleged victim's recantations may sometimes be insufficient, given that the magistrate must view all evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution, close quote. Judge, Your Honor has heard 4 days of testimony now. The evidence is overwhelming. It's devastating. And the question needs to be asked, the purpose of continuing with testimony if it's long and drawn out. Of course, the defense has the right to call witnesses, but it needs to be within the context of this preliminary hearing. So again, we may be lodging a standing objection of relevance and exceeding the scope of this hearing. That's my record.
Thank you, Mr. Grunander. Do other of the parties wish to be heard as it relates to Mr. Grunander's statement? To the defense?
I'm not sure what was being requested by Mr. Grunlander. As I indicated to the court during the testimony of the last witness, we had discussion with the state prior to the start. We had a scheduled date for the court to rule on objections. And the purpose of that hearing was so that we wouldn't have to fly witnesses out from the East Coast if there was going to be a standing objection. Prior to that hearing taking place, the state contacted us after they had participated in interviews of Ms. Oliver and the other experts and indicated to us, and we indicated to the court, that there was going to be no standing objection to the testimony of these witnesses. So if he's lodging a standing objection now, I think he's waived it, or he should be stopped from asserting it, given the circumstances. I didn't hear that he was asserting that, and I intend to keep this next witness focused on the issue that I think is relevant, which is the state presented DNA reports through a non-expert. They selectively read into the record a portion of those reports, which left an extremely misleading impression of the significance of that evidence. So I have the author of the report here, and I'm going to hopefully educate the court on what the limitations are.
He gonna educate y'all.
And that's it. I hope to be done with the witness by noon, direct and cross, and
Not gonna
and
happen.
that will be the end of it.
All right, thank you, Mr. Burt. And before I have you call the witness, just want to make sure that the media had a, well, I'm not sure if the media needs to be heard on Mr. Grunander's response. All right, thank you. All right, Mr. Burt, you may call your next witness.
Thank you. Call Ms. Oliver.
All this horse trading, man. This has got to be
Ms. Oliver, if
frustrating.
you'd like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, ma'am, you may be seated.
Shout out to everybody who's tapped in. All right, back to real jury work. Let's go. Real trial work.
Now, after
Go ahead, hit
you're
that like
seated,
button on the way in.
adjusting
Let's go.
that microphone, bringing it close to you to pick up your testimony from today. Mr. Burt, your witness.
Thank you. Could you tell us your name, please?
Caitlin Oliver, Oliver.
And Ms. Oliver, could you bring that mic a little bit closer, so I want to make sure your voice is projected. Thank you. What do you do for a living?
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA section chief.
And how long have you held that position?
I've been a section chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a forensic biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA quality manager.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall that around September 11th, you received a request to do some DNA work at the request of the state of Utah?
Yes.
Could we display State's Exhibit 30, which is in evidence?
So I'm not really certain why they're muting it. I don't get that part, but thank y'all, everybody who's tapped in. I have no idea why we're muting this. Yeah, I don't know what. I thought that was for, okay, I might not have been hearing it correctly then. I was thinking it's for September, but I guess it means now. So he just made a judgment on the, okay. I don't think that's good, but man. I do not think that's a good look, but oh well. Nothing we can do about it. I just have to sit here and tell jokes. Tell bad jokes until further notice. Lip readers in the chat. Well, he's not saying anything. Judge Graff isn't saying anything. This definitely is less than optimal. Let's just say it like that. Less than optimal, to say the least. Okay. I am trying to get the car guy to look at the car and get his opinion on the matter. I'm telling him to use duct tape. See if that works. Well, duct tape, my dude. All right. That's what I thought. But I thought it started in September, man. This is definitely not what I thought it would be. All right.
For instance, the next sample down.
That's wild.
1.2, where the state read paragraph D, admitted paragraph F, you state in F, based on this calculation, there is evidentiary support for the inclusion of Tyler Robinson, correct? As a possible contributor.
Correct.
Mr. Burt, I just want to interrupt.
Sure.
I was made aware of a question about the media as it reflects this order. So the question was whether audio could be transmitted, and my ruling covered the video display of any exhibits. And so I just want to make sure that's the understanding of all the parties, that the audio of your portion discussing evidence is that you understand that that's going to be captured by the camera and displayed, but not any exhibits displayed. Is that your understanding?
That is my understanding of the court's ruling, yes.
And to the state?
Yes.
And to the media?
Okay, then turn the audio on.
Well, that's why I give my notation to begin the morning that the parties are responsible to monitor their monitors. And that's there because they're entitled to view it, but they're responsible to ensure that the monitors, as the camera is picking up the courtroom, it's directed not to focus on the monitors, but inevitable capture may occur, and that's why that instruction is given.
Your Honor, Jeff Nine on behalf of the victim. You cannot see it in court, nor is it, so I don't know if it is very possible.
Oh man, this is so.
I don't understand.
I don't understand
It's
either.
not being published on this
It's not
one.
being published on the monitor to the court's right.
Right, the order of the court based as a sanction is no exhibits will be displayed.
In the courtroom entirety?
As it stands right now, yes, that's correct. Okay, please approach the lectern.
Your Honor, it's just hard for the victim's family to be able to follow the evidence if everyone but the victim's family is able to view the exhibits here in court.
Thank you, I appreciate your concern. This monitor is not on either. So it's only the attorneys. The attorneys have a right to view what exhibits are being displayed, to make their motions, objections, and to see it. It is the court's discretion on what's displayed in the courtroom for publication, and the court issued a sanction given the events of yesterday, and that's the court's ruling.
Your Honor, I just asked the court to consider the victim has the right to be present, obviously, at the hearing. And the presence without being able to see the exhibits, again, it's our position, is not meaningful.
Thank you, I appreciate your concerns. Mr. Burke.
Could you redisplay exhibit 30, please? And again, while he's doing that, that same conclusion where you include the language, go back to that page, please, 5. Use the term, there is evidentiary support and possible contributor. I want to focus your attention on the words evidentiary support. We've had a prior witness testify that, from the FBI, testified that they use a scale and they characterize the support along the lines of strong. Are you familiar with that type of a scale?
Yes.
Does your agency employ that scale?
We can come to 5 conclusions at our agency, so there can either be exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion.
And I take it from what you just said, you don't use these qualifiers strongly. The word strongly include things of that nature.
Yes, we don't use a verbal scale at our laboratory.
Is that a scientific phrase when you talk about instead of saying that there's support for an inclusion, you instead say there is strong support for the conclusion?
So our laboratory doesn't use a verbal scale due to the fact that they add subjective words to the front of this word support. It is our stance that the likelihood ratio statistic, the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion.
Thank you. Would you go to page 8 of the report and highlight the very top of the first 2 sentences? You included this language in your report, correct?
Correct.
And in fact, you included this language in all 3 of your reports, referring to the conclusions conform with the relevant Department of Justice policy on uniform language.
That's correct.
Right. And why do you include that language in all 3 of your reports?
It's standard language for our reports. Our reports adhere to the DOJ Ultra statement.
Okay. And could you go now to Exhibit Oliver 4 for the witness only? Not admitted yet. Are you familiar with this document, the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examination using probabilistic genotyping systems?
Yes, I am.
Right. And would you go to page 4 of that document, please? And the court has heard some prior testimony about this Department of Justice directive. What is ATF's, what is your understanding of what the qualifications and limitations are that are required by this policy of the Department of Justice? What are you not supposed to be saying in connection with the reports that you wrote in this case?
There's a few things that the Ultra document states. First, it states if you use a verbal scale, which we do not, then you need to use the one dictated in the document. This is in an effort to unify the language coming out of DOJ laboratories. It also says that we cannot state that our evidence is infallible, nor can we state that there is a inconclusive result.
Shall not state that it's infallible or have a 0 error rate, correct?
Correct.
It also states, does it not, that you shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
Correct.
And are your reports in conformity with that? You're not stating or implying that anything you did here is asserting an absolute identification of someone as the source of any of the evidence that you examined, correct?
Correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's why we report a likelihood ratio, to speak to that uncertainty with a statistic.
All right, and would you go to the next page of that document? this policy requires that you not state or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty. You didn't do that in any of your reports, correct?
Correct.
You're not asserting anything with respect to any reasonable degree of scientific certainty,
Correct.
correct? Now, when, you can take that down. When did you first receive the assignment in this case?
I would have to refer to my case record to know the exact date.
Do you have those in front of you?
I do not.
Okay, let me pull up Oliver 3 for the witness only. And go to the third page. Does that third page help refresh your memory on when you may have received this case?
Yes, on September 12th, 2025.
Okay. Is that when you first started doing work on the case, do you think?
Yes, it is.
Now, prior to doing work on the case, did you receive permission from someone to consume any samples in the case?
Yes, I did.
And could you go to page 15 of those case notes, please? Again, for the witness only. Do you recognize this email?
Yes, I do.
And can you tell me what the email is and what information it conveyed to you in connection with your examination?
Yeah, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Now, does your policy have, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the National NRC recommended a policy that samples be split wherever possible at the front end of the analysis to allow for independent examination.
Where possible, yes, that's correct.
Right, and they did that because it was their conclusion, was it not, that a wrongfully accused person's best insurance against the possibility of being falsely incriminated is the opportunity to have the testing repeated. Such an opportunity should be provided whenever feasible.
Correct.
Okay, could you now go back to Exhibit 30? Page 8. Were certain DNA samples consumed in your analysis?
Yes, they were.
And for the record, are those listed on page 8 of your report?
Yes, they are.
Which samples were entirely consumed in your analysis?
That would be exhibits 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1.
Okay. Then are there a number of samples listed above there in the report where you say the DNA extracts will be retained? And then you list 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1.
Correct.
Does that mean that those are all swab samples, correct?
They were swabs, yes.
All right. Does that mean, does your report mean that you consume the swabs, but you have some liquid extract remaining as to those samples?
Correct.
Now, are all of the samples, let's talk about the samples in Plaintiff's Exhibit 30. Were all of the samples you looked at there mixed samples?
I refer to my tables in my report.
Sure. Go to page 2, please.
And can we go to page 3 and 4?
3 and 4, please.
With the exception of the known samples from the known individual, that was a single source sample, but otherwise the evidence samples were all mixtures.
And in many cases, they were mixtures of sometimes 4 and 5 people, correct?
Correct.
Now, when you look at mixtures, such as the ones in this case, you use terms like major and minor contributor, right?
Correct.
Is that language meant to convey that anything with respect to activity of anybody who might be assigned to that DNA weight? In other words, are you saying the person you label as a major contributor was engaged in any sort of activity? Is there any connection between the use of that language and activity?
None of the testing that I performed could speak to activity or what activity led to the deposition of the DNA.
So nothing in your report, if somebody reads that and says, oh, this one says this person is a major contributor, you're not commenting on anything about the person's activity, correct?
Correct.
And is it true also that there are also several other limitations concerning the language of your report that it's important for courts and people who are reading the report to understand?
I'm sorry, what was the question?
Are there other limitations in addition to the one we just reviewed that it's important to understand about the language you use in your report?
In terms, is there something specific that you're?
Yeah, there is. Could you go to Baker Exhibit 30, page 1, for the witness only? Are you familiar with this publication?
Yes.
This is a publication by the National Institute of Standards and Technology called Forensic DNA Interpretation and Human Factors.
Correct.
This is put together as a guidance document for practitioners on what, to simplify it, essentially what to say and what not to say.
I don't know that I would call it a guidance document. NIST is not a regulatory body for DNA testing. It was a report that looked into forensic DNA reporting and specific human factors that could affect our testing. So they may have had recommendations, but as far as them being a regulatory body that's issuing guidelines, I wouldn't state that.
Okay, that's fine. Could you go to 136, please? $136. This is Baker 30. Keep going. There we go, right there. Wait, 135, I'm sorry.
So I'm wondering, do you think that they're just having her
and then scroll down to. the next.
Using her to debunk the other experts? Is that what you all are thinking?
So they're making recommendations here as to how the report should be worded, correct?
Correct.
Let me ask you whether you agree with some of these limitations, or they call them caveats. They talk about how you describe the number of contributors, and they say the true number of contributors of DNA to an item can never be known. Do you agree with that?
Yes.
Okay. They also say, let me ask one question before I ask this one, which is, do you use something called a reporting cap in all three of your reports?
Yes, so for our likelihood ratio statistics, we cap the statistic at 1 trillion. The actual number could be a lot higher. It could be quintillion, octillion. We chose 1 trillion because it has meaning, I think, to people that can understand what 1 trillion is. An octillion and a quintillion gets a little high at that point, so we cap at 1 trillion.
And they talk here, do they not, about how you convey the idea of a reporting cap? And they say the LR reporting cap was chosen because of the limitation of biostatistical modeling and independence assumptions of STR loci. Do you agree that that's why the cap is chosen?
I believe we chose our cap for the reason I stated.
Do you disagree with that statement in terms of why the cap is chosen?
I'm not familiar with the paper that's referenced there, so I would have to familiarize myself before I said I agreed or disagreed.
Fair enough. And then they also suggest that you alert in your report that profile descriptors cannot be applied to activity level issues. Do you agree with that?
Yes, so this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition.
Right. DNA profiles may be described as major, minor. However, these descriptors should not be interpreted in the context of a decision regarding the nature or the mechanisms, actions, or timing that led to the deposition of the DNA. You agree with that?
Correct, yes.
All right. And then the other sort of limitation, convey that the DNA results cannot be interpreted as the analyst providing an opinion regarding who the source of the DNA is.
Yes, so this is, once again, we don't make source attribution statements. We will say there's support for inclusion, and then we back up that with a statistic.
So from a scientific standpoint, you couldn't read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, Mr. Robinson's DNA is found on this item. That's a source attribution, is it not?
Correct, yes.
And that would not be scientifically defensible, would it?
Correct.
Okay. Another limitation they talk about on likelihood ratios, on the next page, please, 137. Likelihood ratios cannot speak to the likelihood of a proposition, only to the probability of the results given a pair of propositions. Do you agree with that?
Yes.
Explain that, because that's a little above my pay grade in terms of understanding.
So a likelihood ratio statistic compares the probability of the DNA profile of the evidence given two competing hypotheses or two competing scenarios. Typically, the first is that the person of interest is included, and then the exclusionary hypothesis would be that the person of interest is excluded, so there's a random, unknown, unrelated individual contributing.
And when they're elaborating on that point, they say a likelihood ratio indicates if and to what extent the DNA analysis results support one proposition over another. It is not possible on this basis alone to determine which is the most probable proposition. Do you agree with that?
Yes.
Okay. And then the next limitation they suggest you convey is that convey that DNA statistics cannot imply uniqueness within a population. Do you agree that that's a legitimate limitation?
Yes,
And explain what that means. Does that go back to the issue of source? You can't assign a source to a DNA sample?
correct.
Okay. It says you should delineate the meaning of a verbal qualifier, but you didn't use one in this case, right?
Correct.
Okay. Now, you mentioned that your testing cannot, and correct me if I'm wrong, I don't mischaracterize it. Your testing, none of the testing in any of the three reports can answer the question of how and when DNA got deposited. Is that true?
That is true. DNA can't speak to the activity that led to the deposition of the DNA.
And the report says, with regard to that issue, with the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped. Alternatively, a person's DNA may be present when they were not involved in the crime. Do you agree with that?
Yes, once again, I cannot speak to the activity.
Can you explain how it's possible that a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped?
So it's possible if, say, the pen that you're sitting there using for the week, you say hand it off to the judge, and the judge then touches it for a period of time, and then I swab it. It doesn't speak to who handled it last. I could test that. I could get both of your profiles. I wouldn't know which person was the last person to handle that item.
All right. And similarly, if you had a lot of DNA on your hand, we shook hands, I then went to pick up an exhibit, a gun, I touched the trigger of it, your DNA could be on that trigger, right?
It is possible, yes.
Okay, even though you never touched the gun.
Yes.
And that's why, because of those possibilities, you can't make any assessment of how or when DNA got deposited, correct?
Correct.
How long can DNA persist on an item?
DNA is quite stable over time. It can be broken down due to environmental insults, so things like heat and humidity are known to break down DNA over time. But I couldn't give you an exact number.
Were certain of the samples that you tested in this case degraded samples?
There was degradation present in some of the samples.
And what can cause degradation?
Like I said, there's environmental insults, heat, humidity.
Now, the second report that you wrote had to do with a Dremel item that was taken from Mr. Robinson's home.
Correct.
And did you request certain what are called elimination samples in regard to items that were recovered from his home?
Yes.
Tell the court what an elimination sample is as opposed to a sample that relates to what's called a POI, person of interest.
So an elimination sample is a sample taken from a known individual that it may be assumed that they could have come into contact with it. If I were to say swab your vehicle, then I would want your DNA sample as an elimination to eliminate you in order to look for any additional DNA that may be there.
And you say they're assumed contributors because depending upon the location, for instance, somebody's house, you would expect if there were multiple people in that house that perhaps everybody in the house could contribute to a certain DNA result.
It's possible.
So you'd want samples from all those folks to see if they contributed to an item that would be associated with a place where they congregated.
Correct.
And I noticed from your case file that you also requested, but I don't think you received, elimination samples from agents who were involved in this case.
Correct.
Why do you request those samples?
The type of testing we perform is quite sensitive, and so it is a standard practice that we request elimination samples from any of the investigators involved in order to potentially eliminate them in case they could have contaminated the evidence.
Okay. Now, in report number 157, if you could bring that up, please. Oliver 157, which has been admitted. The elimination samples that you requested in connection with item C's from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twigs, correct?
Correct.
And that's because you had information that those people were associated with the house.
Correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct.
Then you compared their types to what you found on the evidence.
Correct.
And for a certain number of those samples, you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay, and if you could scroll down to page 4, which is the table, I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there was support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolt of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And there
Again,
was-
not because he's a suspect, but because he's associated with that premise.
Correct, and there would have been a likelihood ratio statistic calculated and to go along with that.
Okay, could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swap number 1.6, or a profile that indicated he was a possible contributor.
There was support for inclusion of Matthew Robinson.
Okay. And next page, actually go to page 7. You found support for inclusion of Lance Twigs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twigs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twigs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twigs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area I want to ask you about is, you're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for Next Generation Sequencing. It's a DNA technique that sequences your DNA, so it looks at the individual sequence of your DNA.
And is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
I told you they were going to do this.
And that's sold by a company in New Zealand, that software?
No, it's not Israel.
Have
Don't
they
let it be
developed
Israel.
another program called STR Mix NGS?
I'm not aware of NGS software.
Could you go to 156, Oliver
I knew
156?
it. I knew it.
Let me know when you're there. Are you aware that the developers are selling a product called STR Mix NGS?
I was not aware, no.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals, and there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number of repeats present at that location. So the testing we're performing is looking at those length variations. There's a distinction between, say, if you have 10 repeats versus 12 repeats.
But you're not looking within those lengths to see what the sequence of the DNA is.
Correct.
And that's what this new technology is designed to look at.
Correct.
And the reason it's designed to look at that is because it's been found that there are DNA areas that are different in sequence, even though they're the same length. Is that true?
I think the reason for developing NGS software is to add another tool to a forensic biologist tool belt.
Okay. Now, could you go to 154, please, for the witness only? You're familiar with this chart?
Yes.
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
No, it looks like,
No, you were right, 154. Yeah, this is one, what's the exhibit on this? Okay. You're familiar with this chart, right?
I reviewed the first page of this chart. I have
Sure.
not reviewed the entire
Go to the
thing.
first page. This lists the alleles that you found, correct?
For the known samples, yes.
Okay, now go to the second page. And is it true that for the alleles of interest in this case, one of the alleles of interest is at the D3 location, allele 17?
One of the locations that we look at on the DNA strand is called D3. That's a location, yes.
Right, and in this case, the 17 allele is important because Mr. Robinson had a 17 allele, correct?
Correct.
And some of the evidence had a 17 allele
Correct.
at that location.
Correct.
So as I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's how we do our comparison. So it's not just number matching. We're using STR Mix, the STAR Mix software, in order to perform an analysis of the software that looks at the possibilities for a DNA profile and make comparison to the knowns that way. We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct.
But the bottom line is you're comparing alleles one against another.
Correct.
So if a person is a 17-17 and the evidence sample is a 1717, you're looking at that comparison.
Correct,
And again, measuring only length.
correct.
But it's true, is it not, that researchers have found that that particular allele, the D317 allele, that there are actually 3 different 17s, 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele, but the sequence within that 17 allele is different. So 2 people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A, a 17B, and a 17C, correct?
Objection, relevance to probable cause hearing. At this point, I think we've once again gone beyond probable cause, and based on Mr. Grunlander's argument, I would invoke his argument here in the case law that he referenced, and I object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection. It will be reframed, and we'll go from there.
It's true, is it not, that at least 1, 2, 3, 5 of the locations of interest in this case, researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length.
Objection, relevance. The witness has testified she does not do sequencing analysis here, and that's what the question is asking, is about sequencing analysis.
Counsel?
The point, though, is that her testing cannot distinguish between these isoalleles, and therefore it goes to the weight of the comparisons.
But if she didn't do that,
Yeah, that's the point, is that she didn't do it, and therefore she's not in a position to draw conclusions.
Mr. McBride?
That proffer is inaccurate, that she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant to her testimony.
Let me see if I could lay a further foundation.
All right, so I'm going to sustain the objection.
Sure.
And the question may be re-asked if counsel chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared a non-match, regardless of how many other loci match?
No, it's not quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So it's possible for DNA evidence we spoke about, it's possible that DNA evidence be degraded. In a case like that, there may be the potential that some of the profile has what we call dropped out. So it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you had a difference in sequence between a known and a question across many loci, would you exclude the person?
It depends
Again,
on.
objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burt?
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness and her firsthand knowledge, I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
Correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you.
Oh my goodness, come on.
From the NIST mixture study. An likelihood ratio numeric value is not a measurement of a physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors you assume?
No, it does not.
It has no effect whatsoever?
It can have an effect. It's possible. It's possible multiple other factors could contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I would say that I use my my training, education, and experience in order to determine the number of contributors present in a profile.
Well, I noticed throughout your report, you use the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least five contributors, at least one of which is male. And for 1.1, you say, the profile is consistent with at least 4 contributors. I assume by the word at least, you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures. Familiar with that, right?
Yes.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
It's possible for them to present, yes.
Oh, it doesn't say it's possible. It says, for example, approximately, in all cases, assuming a mixture as a result of the combination of 3 people must be done with caution. For example, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
You said you're referencing my SOP?
Yes,
Is it possible for me to take a look at it?
sure.
Your Honor, I'm going to object at this point. The point that defense counsel is getting at is made in the last answer, which is that the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood, but that has nothing to do with the probable cause determination. Even if it's difficult, the inferences and the evidence is weighed in favor of the state. The court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury, but not for this court.
Well, he's implying this is going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right, I'll allow this question, so I'll
Thank you.
overrule the objection. She may review the material and
So could you bring up
question can be rephrased.
one, exhibit Oliver 148? This is your SOP document, correct?
Correct.
And then go to page 83. Did I read that correctly?
Yes,
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2 or 3-person mixtures?
it's possible.
Thank you. That's all I have.
Thank you. We've been going for a bit, and depending on how much cross, I'm trying to decide if a break is warranted or if Mr. McBride, you wish.
No,
your
let's keep
cross
going. Let's get it
is
done, brother.
excluded. Again, not trying to say which way you
Bless
should
his
go, I'm
heart.
just trying to weigh whether we should take a break.
I will probably be, I'll probably be 20 minutes.
All right,
Come
let's
on, tough it out.
Let's just keep going, and then
Yeah.
at that point, we can.
Be a gangster.
Take a break. Thank you, Mr. McBride.
This is crazy. That's him typing too, by the way. I don't know who that is typing, but it's not me.
Good morning.
Morning.
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in
called it
and
accreditation.
audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025 for testing laboratories. And additionally, a DNA-specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes,
The methodologies used in this case have been accepted by courts across the country, correct?
correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're required to perform competency testing prior to participating in casework. And additionally, we participate in twice a year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes,
And at the time you did the testing in this case, did you satisfy those standards?
yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
There were several locations. I'd have to refer to my report.
Okay, would you look at your report, and this is, it looks like report number, or exhibit number 30. If we can pull that up, just for the witness. Thank you, Kimberly.
I wish she had come with her report like the other guy did. He had his report. He had his notes with him. I wonder if that's
Have it for a minute here.
out of line for them to actually have it so they can like go look at it themselves right in front of them.
Okay, if we could go to page number 2, please. Will you just list off the areas of that firearm where there was support for, evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory,
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. The swabs of one 30-06 cartridge case. The swabs of one 30-06 cartridge. And the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions. Let's look at page 5, please. And calculation number 3, exhibit 1.3, do you know where that swab was taken from?
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question, in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6.
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there, the trillion number, it could be far less than that, but you stop your calculations of the statistics at 1 trillion, is that right?
Correct.
Let us move to page 7 with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the
Who
receiver
is typing like that?
after disassembly. And 2.1
Judge Graff is typing like a
swabs
beast.
of one 30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case, is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
The cartridge is unfired, cartridge case has been fired.
Right. Let's jump back to page 7. And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of 2 individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together, is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown unrelated individual than if they originated from 2 unknown unrelated individuals.
And did you make a conclusion here as well about the a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
Shout out to Captain Jax up in here, blessing us with 20. Thank you so very much. And Captain Jax, congratulations. You are the stream sponsor. You are the cookout representative. What does she say here? And she used to work in law enforcement and such. She says this: I'm behind, but I always had my entire case with me when I testify. Witnesses usually have their reports. Some judges don't want you to have them, and you must ask before referring to them. Shout out for sure. It looks like Judge Graff allowed, I think the guy's name was Bagley, and I think Dennis earlier this week. I might be wrong, but I think they had their reports or notes or something. So hopefully, I just think that would be probably a lot smoother if they had all of that stuff at the same time. But we got Captain Jax in the building. Thank you so much for the blessing. Let's get this thing back on the road. Let's get going. Let's go.
Nothing else.
Nothing else? Are they done? Oh gosh.
The 1.3 sample is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct, so they were swabbed together, so I wouldn't be able to say where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample, that was a sample consistent with at least 4 contributors, correct?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing, has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30.
Now, I guess because the report is that she's referring to is a part of the exhibit, is basically evidence, because maybe that might be different, Captain Jax. So like if I just had my notes, I took notes while I was, checking the crime scene, and I had those notes there, that's different than I filled out the report, that the official report that I turned in that the defense and the prosecution are referring to. Is that something different, Captain Jax? Let me know. Okay, let's keep going.
Exhibit 1.1.
I feel smart, man.
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples.
Yeah, the dead horse
no
is
way of
definitely getting
knowing when or
abused.
how the DNA got on those samples, correct?
Correct.
Correct.
You referenced another statistic in your report, which is the statistic related to paragraph E, I guess.
Correct.
Is it what's called the random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio.
We need a gong show for this guy.
Correct. It's based off the likelihood ratio.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute
All right, we're
it
done.
to any person. Can't state it's infallible. Can't state there's a zero error rate. And you can't state that it is a source connected with any one person, correct?
Right, so part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
All we got is horse DNA
Yes,
left,
certainly,
y'all. That's all we got left.
Along with the other limitations we talked about.
Correct.
Thank you, that's all I have.
What? Okay.
Anything further for this witness?
Furry DNA is crazy. That's crazy.
All right. May this witness speaks.
He is angry type. That's exactly what he is.
All right. Thank you, ma'am. Let me step down.
He mad.
Anything further from defense?
Oh, that was their last witness. That was one witness. They said one.
All right. Returning to prosecution.
It's not lunch yet.
Anything further?
No, Judge, we have no rebuttal evidence to present at this
Nothing else. What?
The state has no rebuttal evidence to present at this hearing. However, before we break,
Oh,
there
not
is the,
however.
matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1, so that the victim's family can observe that.
Oh my gosh.
Thank you.
Forgot about that.
All right, do the parties.
Judge was like, I
as
thought we
relates
forgot
to
about
this,
that too.
Briefly, and then court will issue its ruling. And
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
Darn it.
Is that correct, Mr. Robinson? And I note that he's nodding in the affirmative. Thank you, Ms. Visser.
Dang, I wanted him to.
In regards to the outstanding issue about the publication of State's Exhibit 12.1 to the courtroom only, to persons here, any further input from any of the parties before the court issues its ruling?
Jeff and I, on behalf of the victim, my understanding is you ruled yesterday that you were going to play it, that you did grant our request. So I don't know if we.
Thank you.
Judge, I might just simply add, given the court's ruling this morning with respect to displaying exhibits, we may want to make a record with the live streaming folks here that it's not going to be published.
Thank you. All right, nothing further from any of the parties?
I don't even know.
Okay.
I done gave up. What we got? What'd you say, Doc?
Just,
I'm behind the chat notes. It's totally different
updating
than the
some
official
notes.
report. Okay, cool. So could I have my notes, though? That's what I was wondering. So if I had notes that I transcribed into the official report, Captain Jacks, so I'm at the crime scene, I'm taking notes, this is what I see, this is what I saw, blah, 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 drawing little pictures, whatever. But then I give you my official report. That's what I turn in to the DA and the prosecution and so forth. If I am called to testify, can I refer to those notes or do I have to refer to the report? And can I bring my notes or do I have to let them know or do I have to refer to the report because that's part of the official record? That's what I was trying to figure out. I hope that made sense. Thank you, Captain Jacks. I really hope that made sense. Okay, let's finish up.
The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record.
No
Having
sanctions.
considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted to outside the courtroom, and no broader and is taking the least restrictive means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative. The same in-court viewing rules applies to all parties and courtroom attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the state. So could the camera operator let me know when we're switched to an audio only? We are? Okay.
As I'm looking at you.
And as it's switched to audio only, to the state, now my understanding there's no audio on this surveillance on 12.1, is that correct? All right.
So this could be where they can start instituting a delay. That's what they need to start doing.
And I'm going to rule that this also applies to the still photographer. It cannot be captured, the screen in any way. I noted video recording, but I intend as well as no still capture of any of the monitors during the publication of 12.1. All right.
Shout out for sure. Well, while they're doing that, Captain Jax.
And to the state.
Captain Jax is blessing us again. She says, notes are totally different than official report. This defense liar is really reaching, casting doubt, and trying to confuse the issues. I totally believe that's what he's doing. And he got paid to do it. Shout out to him. He's doing his job. He's paid to confuse. He's paid to get this guy off, and he's going to do his very best. He's doing his darndest. But thank you, Captain Jax, again. Y'all put Captain Jax in the chat. She's filling up the cookout. She's filling the cookout with all you good people. So thank you so much, Captain Jax, for sure. Y'all put Captain Jax in the chat for sure. All right, let's finish up. Oh, well, actually, there's nothing to see. It's just a seal.
I know. If you're ready, let's go ahead and play it now.
Ain't nothing to see. We can't see nothing. We'll see. What we're seeing here is okay, so I could have my notes. Okay, there we go. That's it. Because I think the guy on Monday, or was it Monday or Tuesday, he had notes. He's like, I'm going to refer to my notes. And it just seemed like it went faster. Shout out. Thank you so much, Captain Jax. She filling the cookout. She getting the cookout full. Bring your Tupperware. I'm being saying this to Captain Jackson and I are on the same page, frequency. Oh, then you're on a good frequency then. You're on a good page if you're with Captain Jax. All right, so if you're just jumping in, they're looking at a video from yesterday that was supposed to be shared with the family, but they had a whole bunch of horse trading, a lot of upsetness about it. So the judge said that they would do it at the end. This is, I guess, technically the end. Y'all think we might be done by lunch? Yo. I had to go send my mother-in-law her birthday cards. I could still make it. We can hear their audio. There's no audio on the video. It's just some video clip. I didn't think it was that long though. Objection to birthday cards? Really? Objection, no birthday cards. Really? Why not? You don't send birthday cards? Come on now, Ruben. Now, Ruben. What did Captain Jack say over here? Yes, you can have notes. I always shredded my notes because no one else could read my chicken scratch. And I put everything in my report. Shout out for sure. Yeah, I just was wondering. Overruled. Right. Come on, Ruben. Have a little bit of, come on, man. Have a little bit of heart. Have a little bit of heart, man. Come on. Thank you, Captain Jacks. I really appreciate it. And y'all say thank you because the cookout is full because of Captain Jacks. She's a stream sponsor today. Make sure y'all say thank you to the Caps Jacks. I don't know what to do with myself. Are they going to be done before lunchtime? Yo, that's going to be crazy. Come on, Susie. Susie, come on. You don't, come on. Hold out hope. Hope against hope. Come on. Susie said, don't hold your breath. And is that like a yoga person? You wild, man. That's so wild. Well, yeah, okay. Let me just be quiet. That's a good point, too. Let me just shut up. I'll find something else to talk about. We got the plumbing fixed, by the way, if you were wondering. Thank y'all so much. We got the plumber fixed, the leaky sink. We got that taken care of. Also, the water pressure issue, we got that resolved. They haven't told me about my car yet. And all you crazy people talking about using duct tape to fix my daughter's car, you all are all in 0-second timeout. Everybody go over and buy a bumper sticker. Are you suing Candace Owens or being sued by Candace Owens? Please go grab yourself one. Grab a shirt too, by the way. Y'all are wild. I bet he used hot. I hope not. He replaced the garbage disposal. So apparently garbage disposals get old and they start to leak. And the garbage disposal was getting old and it was leaking. So we got that resolved. Praise God. Jay Witt, wait, what'd you say? Do you see her prayer? Man, don't even get me started on that. Do not even get me started on that. I think they're showing the enhanced video, yes. But there was no audio on it. Jason, if you can't fix it with duct tape, it's not worth fixing at all. Dog, Adam? Adam, it's my daughter's car, bro. Hold on, let me find the picture again. My dude, come on, man. Adam, I expect better from you, devil dog. I expect better from you. Some of these other yahoos, that's what they get. I don't expect high. I don't have high expectations. But for you, devil dog, I expect better from you, man. Let me show y'all real quick, man. This is what. So the dog bit my daughter's car yesterday. Real quick, while he over there angry typing. All right, so there's my daughter's car. No, you're not gonna put no duct tape on that, man. Come on. This rascal said he fixed his whole car with duct tape. And the bad thing is I actually probably believe that. But no, I'm not put my daughter out there like that. I put my girl out there. Oh, okay, that's right. Y'all got me with this red green. I gotta watch that too. It was a big dog. It was a Lexus dog bit my daughter's car. It was a Lexus dog. And I think, if I'm not mistaken, I think she went to University of Georgia. I think that's what she said. Yeah, she went to UGA. Go Dogs. There's a lot of not seriousness here. I just want y'all to know that. We are not being serious today at all. All right, so they're still whatevering. They're watching something. Right, she was a bulldog. Go Dogs. Didn't hit my car. Ooh. I don't think it's going to probably be about that much because, I mean, that quarter panel is crumpled up pretty nice. So there's a Lexus dog hit it. I have no earthly clue what they're doing, but all right. And most of y'all know I used to be a school teacher. So one of the things that you have to do as a school teacher is you must, it is imperative that you are able to improvise, because no matter what, it doesn't matter how much you plan. It doesn't matter how much you foreshadow. It doesn't matter. It doesn't matter. It doesn't matter. Something is going to go wrong and you're going to have to be stuck there improvising. And I'm telling you right now, if I can't do anything, I can probably improv for a long, long time. Because I've done it. I've had technology breakdown during observations. I've had parents walk in when I was about to take the kids out for recess. I've had all kinds of crazy stuff. And you have to be able to be like, oh, this is exactly what we're going to do. Well, we were ready to do this. We're ready. Yeah, I think that quarter panel, that front quarter is not cute. But let me see real quick. Yeah, I'm waiting for the person to call me back that they went and saw the car and give me their assessment. So we'll see what happens. I really wanted to, because my second born was going to use that car this year to go to school. So I really want her to be able to drive to school this year. So, but Jax, they over here trying to fix everything. They out here fixing with duct tape, saran wrap, Gorilla Glue, Bondo. Look, I'm losing faith in this live stream, Captain Jax. Only you have restored my faith in the live stream. I'm like, for real? Come on, y'all. Come on, man. They out here talking about some hot glue, Gorilla Glue. They're wilding out. Oh, I just realized, man, they knocked the fog light out. I just realized that. The fog light's missing. They just look. Oh yeah, Murphy was a principal of my school. He was a principal and the academic coach. You can buy white duct tape. Heather, why are you like this? Just use flex tape. See, I'm thinking you all are going to be serious. I'm thinking you all are feeling my pain. Like, we got to work with Jay Witt. We're trying to help Jay Witt out. Y'all out here talking about duct tape and flex tape and hot glue and Gorilla Glue. Again, like I told y'all earlier, the reason aliens won't talk to us is because of this kind of shenanigans. This is it. This is why the aliens don't even like us. Give the car some IB. Now, I have to admit, of all the crazy things y'all have said today, that one right there, I did not see that one coming. I did not see that one coming. Uh-oh. Why does it look like it's about to rain outside? Okay, they're back.
Stacy, give it 12.1 video transmission may resume. Just let me know when that is
Rivets
live.
is out of control.
All right, thank you. Does either party need the benefit of the record?
State does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the recording. Thank you. The court appreciates the professionalism, civility, and respect shown by counsel, the parties, and all persons in attendance throughout the proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.
What? They're done? Oh, man, come on. We should have took some bets. Darn it, why did we bet? Oh, we should have had some bets going on. Oh, man. Oh, man, I'm kicking myself. Yeah, it is 2 months. Dang. Wow, September 1st. Now, if I'm not mistaken, and somebody please correct me, isn't he going to announce, though, what he decides to do before then, or is that what he's going to do on September 1st? Because that does seem like a long time. Like, dang, dude, come on, man. Wow, I did not see that coming. I did not see that comment. Giselle says, thank you, Jay Witt, for streaming this prelim. Much appreciated. Thank you so much for the 10. I appreciate y'all for hanging in there with me because good gracious alive. These are fun, though, I have to admit. Watching these and not knowing what we're talking about and just having fun talking about it is probably the most 1980s thing ever that we can do in 2026. And y'all know what I'm talking about. When you used to sit on the phone with your friends and watch something on TV and y'all would talk about it while you were watching it, couldn't rewind, couldn't back it up, couldn't pause, you used to watch TV together. That's exactly what this is. But we just have it a little bit better because we can actually stop it. That's the only thing that makes it better. It is, wow, I did not see this coming. I did not see this coming. I just knew it was going to go all day. I just knew it. I don't even know what to do with myself, man. Are we going to take Abuela her birthday cards? Somebody in the kitchen, they don't want to talk to me. That is craziness. So if I'm not mistaken, and somebody can correct me, what's the decision on September 1st? September 1st, they will come back in and they're going to argue whether or not this whole week has proven that Tyler Robinson needs to go to trial or that it has disproven that Tyler Robinson needs to go to trial and this whole thing needs to be thrown out. That's what it is. So that's what this whole week has been for, the preliminary trial, and he's going to make his decision on the 1st of September, if I'm understanding it correctly. There's much smarter people that are going to be tapped in on this one than me. Trust me. We're going to have some recaps tomorrow. So tomorrow, Saturday, I'm doing 20 lies that Candace has told, myths, fan fiction, false narratives that have been disproven by the Tyler Robinson decision. I've got some good ones too, by the way. So this is going to be fun. So we're going to do 20 lies that Candace has told that have been disproven by this. And that'll be tomorrow evening at 6 p.m. Eastern Standard Time. Yeah, I don't see any reason. It's almost like a given. It's almost like a given. Like, what are we doing? If you can prove that he was there, which I believe they did that, you can prove that the Charlie Kirk is deceased. We already know that. So what are we talking about? But do you know? No. You don't make me play it. You want me to play it? I'll play it now. All right. So that was way better than I thought. Tyler Robinson has like 50 days to plead guilty to avoid damning trial. Look, I've been praying that he would plead guilty. Oh, wait, what do you say here? It makes me mad they didn't do closing. Right. But they're going to do closing on the 1st of September. It is kind of like, what are we doing? Now, I will say this, though. To be fair, I think that Judge Graff is trying his very best to not catch any flack because he moved too fast. He was too flippant. He was showing bias. I think we could all agree, like, he is not being biased per se. I think that's what he's trying to do, in my opinion. Now, does that still mean that Tyler Robinson is innocent? No, by no means a measure. But I think he's trying to make sure that he gets a fair trial. And I mean, I can't hate on Judge Graff for that. I can't be mad at him for that at all. Tyler can possibly plead guilty and avoid it. Yeah, he could. If they offer it, he can plead it right now. Thank you so much. Okay. Dude, 2 months. But also another thing to think about, it takes them a long time to get the court transcripts ready, because when they get them ready for them, they have to have the court transcripts ready. It does take a while for those. I mean, think about it. The Carmelo Anthony trial has been over for a month. They ain't seen hide nor hair of those court transcripts. So they still working on those. So, and I think they had less, and it was about at the same time, right? About a week. Yeah. So there's still more shenanigans to do. What do you say, Captain Jax? This nonsense is doing oral arguments in September 1st is ridiculous. This nonsense of doing oral arguments September 1st is ridiculous. This delays binding him over, which delays the time of the jury trial. I'm wondering if they're going to try to make a deal. I hope not. Okay, Caps. Okay, Cap. I know you are the stream sponsor. You are sponsoring the cookout. You get to run the ship. However, I personally would appreciate. I honestly would like it if Tyler Robinson just played out and said he did it, throw himself at the mercy of the court. I would rather that. Truth be told, I would rather him just say, confess that he did it, plead for the mercy of the court. That's it. Because as much as, this is fun, y'all know good and well that trial is going to be a hot, steaming pile dumpster fire. Y'all know it. You know it. Like, man, just save everybody. And at the end of the day, we're just people watching. We're just bystanders watching. Think about what this is doing to the Kirk family. That thing's going to be better part of several months long. You want Erica, Mama, and Papa Kirk to be there every single day. And you see, he goes to the buzzer, so he goes from 9 o'clock to 8 o'clock. 9 o'clock to 5 o'clock. Really? Every day? If he could plead out, I would absolutely want him to. If that's a possibility, and he just bury him under the jail, I would be okay with that. But it's on the court, it's on them to make a decision. But I wouldn't be mad about it. Well, thank you so much. I had a great time on your podcast. Well, thank you so much, Raven. I appreciate you hanging out with me. What does Jack say here? 100% agree. Judge is doing an excellent job of being fair to all sides. That's what, again, we've watched several court cases where the judge is clearly in cahoots with another side of the team. And we've seen a lot of shenanigans. And I have to say, Judge Graff is probably the best one that I've seen. Not like I've watched hundreds or anything like that. I'm not a judge whisperer or something. But I think Judge Graff is probably the best one I've seen, bar none, at this with my little bit of limited knowledge. Wait, what did Ruben say? I think the Kirk family wants everything aired out so that the harassment can stop. Oh, I agree. That's what I'm saying. Like, it would put a kibosh on all of that if he just went ahead and said, bada boom, I did it. Oh, yeah. Y'all remember Judge Whitaker? Y'all remember Judge Whitaker? She had a great name, but boy, she gave me gray hair. She right here in Atlanta, too. Y'all still talking about some duct tape. I love you. I just want you to know I love you. I love you so much. Shout out to it not being 90 degrees today. It really looks like it's about to rain. Hold on. Bird. Okay. I'm a trial watcher, and he's up there amongst. Okay, there we go. Just y'all know about it. Does Novak have a podcast? Needs something else to help him sleep. Help me sleep. You're wild, Ruben. The shenanigans are fun, but the shenanigans are fun when they're not. When we feel like you're distant from it. I feel bad for Erica Kurt and the family. I do, that they have to watch this. I can't imagine having to sit in here and watch this and listen to these people horse trade about DNA, and you sitting there for an hour discussing alleles and 17 allele and 17A allele, and man, come on, man. The woman's husband is dead, and you out here talking about this foolishness. Man, that's the part. I just feel bad for that. If it were just shenanigans for shenanigans' sake, or we were, apart from it and really didn't feel like we were invested in it, there's no parasocial commitments, whatever, man. Let's let the shenanigans increase. But I feel bad for them. Can we watch the Okay, let me see that. Okay, let's do that, and then I'll I gotta go drop this stuff off. There was a red green, right? Red green show. Which one? Is there one particular that I need to watch, Heather? Or they're just doing a live show? What is this? Y'all are cracking me up, man. What have y'all? They literally just ended their show. Hold on. They literally just ended. All right, so what am I? This music is crazy. All right, so the red green TV. Let's go here. All right, let's decompress with red green TV. I'm just going to the most recent show. Let's see if I had the most recent show. That or we're going to go watch some auto detailing. Let's go do that. Let's do that. All right, let's see. Dads and duct tape. Okay, well, I mean, I think that probably is what we're going to watch. Let's go. Dads and duct tape. Get myself out here. Hey, thank you so much, Janae. What did she say here? Does Erica and family have any say in prosecutions offering a plea deal? I don't know that one, and I'm gonna give that one over to Captain Jax or somebody else that watches like court TV. I don't think so, and I'm pretty sure. What'd you say? I want to watch Saturday cartoons on Friday. Is that wrong? You wild, Ruben. I think they can ask or like let them know. But I think it's on the state. Don't quote me. Do not quote me. But I think it's on the state to decide. I don't think the state's they're gonna let you know as the family, say, hey, we're gonna offer Johnny, life in prison instead of the death penalty or whatever. But I don't think they have like a say in it per se. No. Now I think they can definitely, that's why they have their own attorney to argue on their behalf, to be like, hey, we want everything possible to be shown because we want, again, probably like somebody said earlier, it gets rid of all the harassment. When you hear this, when you heard Lance Twigs yesterday, that answered a lot of questions, right? That answered a lot of questions. That Bagley guy answered a lot of questions with the video clips of Tyler Robinson walking around campus. That did a lot. That did a whole lot. So I think they can maybe encourage that. I'm gonna use the word encourage, but they don't have a say in it, right? Kind of like your in-laws. They can encourage you to come visit on Thanksgiving. They just can't tell you to come on Thanksgiving. They can say, hey, baby, we really would love to see you. We'd love to see the grandchildren for Thanksgiving. But y'all already got something else with your other in-laws, or you were planning to do a family vacation. They can encourage it, but they can't tell you what to do. Y'all leave me alone with this duct tape. Y'all are out of control. We're going to start a duct tape fund. But, okay, y'all got me red, green TV. I have no idea what y'all are about to expose me to. But see, that's what we're about here. We are here to help the people. I'm going to go ahead and give them a like. I've never seen this. So you all are going to, I don't know what I'm doing.
All right, you had a family get together on the weekend, and you realize that your grandson is being raised by a moron.
Imbecile son-in-law, common affliction.
Well, he married your daughter. There was a tip-off. But now it's serious because there's offspring involved.
A little rascal needs a dad, needs kind of a firm hand. Tradition.
Yeah, and you're afraid that your knee-jerk son-in-law is not going to raise the kid the way you would. Maybe not going to let him play with guns. Not ever going to let him throw the first punch. Or even the second.
Prefers soccer to baseball. Is very, European.
Don't worry, the kid will probably grow up, toughen up, and stop listening to his dad.
It's like we did.
Absolutely. Maybe get arrested a couple of times, Nothing serious, just enough to make him a man.
It's worth 5 years in university.
Oh, yeah.
Yeah.
My dad never hugged me, never held my hand. I turned out all right.
Men should not touch men.
So just give it time. Hopefully the kid will come around.
We did.
Oh, yeah. Want to talk to you guys about what you should tell your kids about life. See, now, in my day, fathers didn't talk that much to their kids. But the only advice my dad ever gave me was, don't slouch like that. It wasn't much, but it meant a lot. I think now I kind of wish that my dad had maybe given me a little more advice. Not that the slouching thing wasn't really terrific, but maybe he could have taught me about career or money or marriage or women or relationships. something along that line, you know. Of course, now it's too late because Dad has left us. He's gone to live in Florida. But I was sitting here thinking, you know, what could I tell the people of today to tell their youngsters, you know, something that would help them out, you know. And I think of the one piece of advice that would have saved me a lot of grief and time and money. And I know what it is. Take care of your teeth. Yeah, friends come and go, families come and go, jobs come and go. But when you're built like I am, you're going to use these babies 5-6 times a day. So you fellas out there, you take your youngsters aside, sit them down and say, hey, take care of your teeth. What the heck, they're not going to listen to you anyway. Remember, I'm pulling for you. We're all in this together. You know, with this lot being up for sale next door, I thought I'd use Handyman Corner to prove a point about the value of having an available parts supply for our various projects. For example, this might just look like a pile of useless crap to say your girlfriend or your wife or your mother, but the rest of us know that this is a tremendous source of raw material for anything we wanted to make. There might be a car in here that's never been built before, or maybe some kind of a customized hovercraft, or, hey, let's build something useful. How about a heart lung machine? Huh? The perfect Father's Day gift that keeps on giving. All right, now what you're gonna need for that, you gotta go through the pile and pick out anything that you could use to suck, pump, compress, or blow. All right, first thing you want to do is lie your patient down inside the freezer. Get his pulse down to around 0, but not too close, so there's no point in going any farther. All right, now you want to take one of these windshield washer units, which becomes the input to take the blood out of the victim, out of the patient, right? What you want to do is you want to hook this into whichever one of his orifices gives you the snuggest fit. And then out of the windshield washer pump, you go into your carburetor. All right, and this is where the blood gets mixed with oxygen. Now, if it's a fat guy, you might want to go with a 4-barrel, maybe put a supercharger on there. Another great thing about the carburetor unit is it's an ideal place where you can add medicine directly into the bloodstream, be it cortisone or maybe a medicinal alcohol like vermouth. And then out of the carburetor, you want to go directly into your water pump. And then out of the water pump, you blast the blood back out of one of these rad hoses, back into the patient. It might be hard finding an orifice that side, especially if he's cold. But anyway, you get all that stuff in there. That takes care of that. Now you want to deal with the lung part of the heart-lung machine. Okay, for that, you want to take a funnel like this, duct tape that right all over the patient's face, maybe put some putty in there and make it a real good seal. And then you hook the other end of the garden hose up to one of the taps on the sink, and then that runs into the nozzle, and now you've replaced the nozzle with, well, let's call it a balloon. That's hooked up to another hose, which runs down into a compressor. We haven't hooked that up yet. And what happens is when the compressor starts up, you see, puts air into the balloon, and then that releases back into your patient. Yeah. So, put that all in there, take the hose out, hook her up into our compressor, and as you can see, the whole unit is all driven by a gas lawnmower. So you don't have to worry about electricity cutting out in the middle of open heart surgery, which I would call a setback. Okay, so another thing, you might want to do all your operations outside, because I'll tell you the gas fumes in one of them small operating theaters. So there, you're all set to go. All you got to do now is wait for the surgeon to say, okay, we're ready for the life support thing to start. But before I do that, I just want to remind you, if women don't find you handsome, they should at least find you handy. All right, getting to work now. 5, 4, 3, 2, 1. Begin life support. There we go. Choke. Yeah. Hang on.
That might be the best thing possible. What did I do to y'all, man? Why in the world?
I want to talk to you guys who've gotten married for the second time, and chances are you're now a stepdad for the first time. Okay, remember this. Stepdads scare kids. Okay? First of all, they think you're weird because you find their mother pretty. It'll take me a while to get over it.
Okay, I will give you, the jokes are pretty funny, though. The jokes are pretty funny. I have no idea what he was making with that situation with the lawnmower, but these jokes are kind of funny.
That one. Plus, you're kind of hard to get used to the way you look first thing in the morning and the way you laugh out loud at Dukes of Hazzard reruns. So just reveal yourself slowly to them, the same way you're planning to do with your new wife. And here's another tip. Spend some time with the kids, okay? I know it's a bit of a nuisance, but if you spend time with them now while they're young, it'll save you spending time driving their mother to penitentiaries on visiting day. I know it's a lot of work. Makes you wish you'd tried a little harder in your first marriage, doesn't it?
Oh.
But here's the upside. If these kids don't turn out, it's not your fault. They're not part of your gene pool. Remember, I'm pulling for you. We're all in this together. This week on Handyman Corner, I thought I'd carry on with the theme of our father-son, father-daughter, mother-son, mother-daughter picnic banquet thing, namely tires. You know,
So this is a variety show. Okay, this is actually kind of funny. All right, I got you. And I like the laugh track, by the way. I don't know why. That's bringing back some good 1980s right there. Okay. I'm picking up what y'all throwing down. What do you say? This dude sounds like a rougher. You know, I can see that. I totally can. Yeah. From Blue's Clues to Data Points. That is hilarious. Oh, that's a good point. Yeah, I like that. Tim Allen. Yeah. Okay, let's finish up.
young girls of today, they're growing up, they're concerned with the ecology, they want to make a difference. So what do you say we make an entire girls' bedroom suite completely out of recycled tires? Girls like pretty things, so I suggest you go with the white wall on that. First thing we could build is a vanity mirror. Yeah, you already got the ebony frame on there with the decorator white accent. And then for your mirror, I suggest you go with the moon disc on there. It's an attractive unit, and it's got the curve on her there, and it makes women look slimmer than they really are. They really appreciate that, especially those 13-year-old girls going through that chunky stage. All right, now why don't we build a dresser for the girls' bedroom? For that one, all you do is stack up a whole bunch of tires and then cut a 4-inch hole in each one using a carpet knife. Perfect. Then once you got the holes cut, you want to stick patches on there to cover up the holes, kind of like your little doorways into the different compartments. So I put a wheel disc between every tire, so you got like little shelving in there. When you put the flaps on, you need some kind of a hinge. You can use metal hinges on that. You could glue some fabric on there. Or,
what
if
in
you like
the
the look of
world?
silver, I suggest the handyman's secret weapon, duct tape. Then once you got all your flaps on there, of course, you can just reach in, get your various articles of clothing. Maybe you keep T-shirts there, and none of my business. And you got your, maybe, what do you got in here? Socks? All right, look at how neat and tidy looking that is. And that's just the beginning. You can
What
also
are we
build a very
doing?
attractive and useful girl's desk. Isn't that a beauty? And how about this is a nice little touch? A beautiful desk lamp. Well, you won't believe this, but this is made out of tires. And we can also make ourselves a dandy little girl's
What's
bed.
what's
What do we
on
use for
fire
a
back
mattress?
there?
Inner tubes make sense, don't they? Why don't we add a little bit of romance, a little bit of excitement? How about one of those Victorian Renaissance, turn-of-the-century 4-poster beds, eh? Girls love that kind of stuff. What can we use for the posts?
I have no idea. An axle. I knew it. Not the whole differential.
How about one of these rear end units, which you can get out of passing vehicles if you dig a big enough pothole? There we go. So now when your teenager gets tired, she can just retire to her tires.
Boy,
Let's see
if we
it's
don't stop
comfortable.
it.
Fools rush in where angels fear the tread. Oh, boy. Oh, gosh. Oh, that is beautiful. So remember, if the women don't find you handsome, they should at least find you handy. And to think we made this out of old rear ends. Actually, you can tell.
What are...
Well, Harold, I'm probably going to regret this, but I've thought it over.
Oh, yeah? Okay, yes.
Well, you know, you are sort of flesh and blood in a way. I
Oh,
guess.
yeah. You know, go ahead.
Seeing as your dad, can't really make it to the... Well, all right, Harold, would you like to come to the father and son banquet with me?
No, I can't, sorry. I'm already going around with somebody else.
What?
Oh, yeah. I ran into a couple kids who are looking for a father figure, namely me. So I'm going to go with them. You already know these boys. I think, you know, Ricky and Ronnie.
The Rittman brothers?
Ritling. Name's Ritling.
Whatever, you know.
What
I
is
don't
he
care about
carrying?
that.
What is
You know
that?
what they probably enjoy? The air dare.
Air dare?
Air dare, having an air dare. Sort of like that game Kaboom, only instead of with a wimpy little balloon, we blow up an inner tube from one of them earth movers. You know? You pay a quarter and you see how far you can take her before she blows. You know, it gets around 200 pounds, her starts to crackle and pop, you know. It'll take a real man to take her over 210.
Uncle Red, I don't think that's the point of a father and son banquet, you know. The kids don't want to stand around and watch somebody blow their arms off. Hey, kids want to do something with their fathers and their brothers and their family and stuff. You know, you should find games that, you know, kids will be interested in.
So you say cancel the air dare?
Yes.
What about the wheel wrench juggling?
Not a good idea.
You wonder why I don't have kids.
Welcome to the Possum Lodge word game, where tonight's grand prize is a weekend for two at the Solitaire Championships. Okay, Uncle Red.
Not Solitaire
You have 30
Championships.
seconds to get Mike Hammer to say this word. Father. Father. And go.
All right, Mike, your mother is married to...
Her job. Exotic dancing's her life.
Oh my gosh.
Okay, I'm talking about the man who took care of you when you were young was your...
Truant officer.
This is a family member, Mike. The man who slept with your mother.
Could you be more specific?
Okay, growing up with just a mom, you knew you had a...
Curfew.
Another word for daddy.
Lifer.
All right, Mike. If your wife has kids, you'll be...
Long gone.
Oh, no.
Whoa. Just like your...
Father.
There. We have a few father and son businesses in our area. You know, like Jones and Son Heating. It's always someone and son. Of course, the someone has a name. The son is just a son. You never see Dad and Jones. Now, when you're the father, it's probably natural to want your son to follow you into business. It's one of the many downsides of success. But you should remember, there are about 10 million different careers out there, and they keep inventing more. MP3 driver repairman, reality TV host, gay bar bouncer. Maybe your kid would rather be one of those. You may think he's like you, but if he doesn't share your taste in music, TV, movies, food, or tattoos, is he going to share your taste in jobs? Or maybe you just want him to be like you.
Well, they got to roll
Check
of
with his
duct
mother.
tape
That
on
may
there.
not be such a hot idea. Instead, let the kid decide for himself. Think of how many times a year you go and visit your dad. How'd you like to see him every day on the other side of your desk? You'd be even lazier than you are now. It's one of the laws of nature that when the father rises, the sun sets. Remember, I'm pulling for you. We're all in this together.
Y'all are wild. All right, so the Red Green Show. That is a crazy show, man. What did I do to y'all? What did I do? That's crazy. That's kind of funny though. I will give you that. I'll give you that. It was funny though. Shout out to the best live chat on the internet. Okay, if you just hopped in, you're wondering like, hey, what's going on? Court is over until September 1st, so 9/1. And we just wanted to decompress for a moment. I am going to run to talk to the claims adjuster and take those birthday cards, even though Ruben is against birthday cards. Even though Ruben's against birthday cards, I am going to take these birthday cards and put them in the mail so they can get up there for next week. The attorney needed duct tape. Y'all are wild, man. That was different. I have to say that was a different kind of show. All right, y'all, but for real, thank y'all so much, everybody. Thank you so much, Captain Jax, for being the cookout sponsor. Oh, I didn't update this. I should have updated this. Captain Jax is definitely the cookout sponsor. Thank you so much for supporting the channel. Thank you to everybody who hung out with us today. This was a little less, this went better than I thought because I did not think they were going to be done. I did not think they were going to be done, but not only were they done, they said, look, we finished. We're out of here. But again, thank y'all so much, everybody. Tomorrow, Saturday, we'll be doing our 20 lies that Candace has told that have been debunked through this trial. I got some good ones. I think you'll enjoy it. And I'm going to finish putting the finishing touches on that this afternoon after I get done with dropping these cards in the mailbox. What did you say here? Special shout out. Thank you so much, brother. God bless you as well, my friend. God bless you as well. It's been a lot of fun. But so that's that. I got a couple of videos I'll be dropping later on today, so you definitely could check those out. Give me your 2 cents. Love for you to continue to support the channel. Swing on over to jwitt.com. Grab yourself a honk if you're being sued by Candace Owens, or honk if you're suing Candace Owens. Bumper sticker, please forgive me. I will be back, Lord willing, tomorrow. We have a good time. So if you don't mind, please tip your waiters on the way out the door. Make sure you hit the like button, say goodbye to your peeps, all that kind of good jazz. I'll see you all later on today in one of the videos I got dropping. I think I have one going on live at 4. But I will see you all real soon. Thank you so much for hanging out with us. This has been a good week. This has been a lot of fun. So I'll see you all real soon, everybody. Grace and peace. Take care. Thank you so much for tuning in to another episode of the Jay Witt Podcast. If you enjoyed today's show, please do me a favor and hit me up with that 3-piece special. Like the video, subscribe, and of course, share it with somebody who would also enjoy this type of content. And make sure you leave a comment, because I do pin the best comments to the top. So thank you so much for tuning in today. And until next time, everybody, grace and peace.